ಇದ್ದಾರೆ ಅಲ್ಲೋ ಕೊಡಿ. ಇಲ್ಲ ಮೂವ್ ಇಲ್ಲ ಮೂವ್. ಎಲ್ಲ GMFC ಎಲ್ಲ ಬ್ರಾಂಚ್ಗೆ ಡೈರೆಕ್ಷನ್ ಇದೆ, ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಡೈರೆಕ್ಷನ್. ಹೇಳಿ ಸರ್. ಒಬ್ಬರಿಂದ ಸರ್ ಧಾರವಾಡ ಮ್ಯಾಟರ್ ಇದ್ದೀರಾ? ಕನೆಕ್ಷನ್ VC.
Yes, madam.
My lord, with my lord's kind permission, my lord, this matter was heard day before yesterday, my lord. But there were two IA orders on two IAs which were challenged, my lord. Only one IA orders is passed, my lord. The other IA was not considered at all, my lord.
What were you doing then?
My lord, that day, my apologies, my lord. That day I was prepared only for taking an adjournment and I was not ready in the matter, my lord. I had also mentioned that since...
This is a matter next week someday.
Yes. Much
yes.
My lord.
In GMCPC matter, especially ordered to be listed before this honorable court. In fact, it was once listed before this honorable court and matter came to be adjourned. Matter may be taken. There is some urgency.
Okay. Oh, is that the matter about elections and all?
No, not election, my lord. This is a matter pertaining to education institution. GMCPC matter.
Why it is listed before me?
Please, me.
Why it is listed before me?
The other bench was disabled and as such it was specially ordered to be listed
Next
before.
Week someday. Yes.
Please.
My lord, appearing for the petitioner in the matter, for almost 1 year they have not decided, the trial court has not decided an application for interim maintenance. And the petitioner is suffering because of this. She's a senior citizen, she's 70 years old.
Here is that petition, WP.
My lord?
Year of the petition.
Year of the petition is 2025, my lord.
When did you file?
We filed it in 2025.
It has never come up before the court?
No, my lord.
Office objections if complied.
On Monday, if the same,
It is complied.
much.
RPFC matter.
Attachment order is passed by the trial court.
Mic is there to use.
Attachment order is passed by the trial court, madam. My husband filed RPFC matter.
When?
It was passed on June 30th, madam,
Of this year.
this year, madam. Thereafter, my lord, my husband filed RPFC petition. That was, my lord, came to be dismissed for non-prosecution. There was a two rival claim over the death benefits of my husband. Now attachment order is passed by the trial court. My lord, therefore I filed applications, my lord, recalling application as well.
Was it dismissed for default?
My lord, during my husband lifetime, it was dismissed in the year 2022.
No, it has to be recalled.
To 24, it was dismissed, madam.
And you kept quiet.
I was not aware of the, my lord, proceedings. I'm legally wedded by.
See for that. It will come in its own.
In service record, my name is there, but attachment.
Yeah,
is
we'll
not.
see. We'll see. Like let it come in its own. Wherever the court time permits, it will come. Yes.
NBW has been issued against the petitioner.
Which year writ petition it is? Which year is the writ petition?
Year, not writ petition, revision petition.
RPFC which year?
RPFC.
Which year?
This year itself.
Yes. Next week someday.
Yes.
Yes, Judge, please kindly be fast.
Because the problem is you don't comply with the orders of the court. You don't take a stay. You don't comply with the orders of the trial court, and suddenly when the execution file, then you will come up.
Actually,
why should we take the matter out of turn?
No, that.
If you're vigilant enough,
only the person.
The moment
in
the order
family
is passed, you should come here. You should make your endeavor to get an interim order.
Can understand,
You keep
but
quiet. We will see. We will see next week.
maybe Monday.
Not Monday.
MFA 3976 of 22. I am made for maintenance. Kindly object. Memo.
Which year is that?
22.
Now it is urgent. It will come. All the matters will come.
Page wise adjournment.
Yes.
Page
You know,
wise.
it's small. There's no necessity to call for the adjournment.
One
Yes.
matter for pertains to that. Any? Kumar?
I appear for the petitioner, my lord.
What is it?
That's this is a vice petition seeking enhancement of interim maintenance. 8,000 was awarded by the family court.
No. Why is it listed? Respondent husband has constructed contracted second marriage, and he is interested for one-time settlement. Both parties shall appear before the Mediation Center, High Court of Karnataka, Dharwad bench on 3/2/2025. Why is it listed before me?
It's a part heard matters. It is listed.
Delete from the list part heard, list before the regular of the court having roster.
Yes.
Yes.
Publish.
List number 1. Serial number 1, parted matter, Sudhakar Pai for petitioner,
Take to appeal for the
Halima
petitioner.
Amin.
For the respondent.
First, your lordship may kindly take 22475.
Hmm?
22475, my lord, both by the same parties.
Hmm.
It's the wife's petition, my lord.
What is the second petition?
Second petition is also arising out of the same MC.
Hmm.
It is against rejection of an application for amendment of pleadings, ma'am.
First is?
First is against 3 interlocutory other orders, ma'am, in the very same MC.
Where is the impugned order?
Yes. First, my lord, your lordship may kindly team in 22475, first matter. 3 impugned orders, my lord, at annexure E, H and L, my lord, are called in question.
Amma, I'm not able to understand what is this procedure of filing one writ petition against so many impugned orders? It is not like, why can't there be 3 different writ petitions?
No, it is between the same parties
I can
and
understand.
3 court fees are paid.
IA, but why you have not filed one IA?
3,
Court fees is not the difficulty.
Ah.
In the morning in some other matter also it happened.
Yes.
No, for example, in a writ petition, I want to dismiss IA1, allow IA2, something else on IA3. How the order can be passed?
in
by the
writ
court?
petition, my lord, under the writ proceeding rules, my lord, by paying different.
That is writ petition rule, writ proceedings rules under 226 is a different aspect.
Yes.
You seek 3 reliefs, that's a different aspect. But in a writ petition under 227, 3 different impugned orders.
Yes.
Arising out, then I allow 1, dismiss 2, do something else on 3, then how do you go? What will happen to the writ petition? What would be the final order? That's the difficulty.
No, here also, my lord, your lordship can allow 1 IA and dismiss 2 IAs. Nothing will happen.
No, but you can
No,
do
no,
3 different writ petitions.
Well, procedure is like that, my lord, because the 3 interlocutory orders in the same MC.
No, writ proceedings rules,
Yes.
226, 227.
Yes.
It definitely makes a difference because it is a writ, you are treating it as a writ.
Yes.
Same thing is adopted. It is difficult in this kind of, in all the CPC matters and GMFC matters.
Yes. But,
Yes, how many IAs are there?
3 IAs are filed.
It's a simple procedure, the same court fees you can pay also. Nothing, no difficulty for the party, convenient for the court. Forget about the rules.
But in civil matters, my lord, we can't do. We have to file.
Civil matters also doing, it doesn't make any difference now.
No, civil matters, it is not,
No.
we are not supposed to.
GMCPC
Yes.
is under 227.
Yes.
GMFC is also under 227. What applies to CPC should apply to this also. You can't treat it on a writ petition under 226. So what is IA number 1?
Yes. My lord, IA number, annexure E, my lord, it is arising out of IA number 6. Not filed by me,
What is IA number 6?
but IA number 6 is for inter-maintenance. Order on IA number 6 is inter-maintenance.
Then what is the next one?
Next one, my lord, annexure H is, my lord, the application filed by the respondent for visitation rights, IA number 8. Third one is, my lord,
This is IA number
first one is, my lord,
6, I understood. Visitation rights?
visitation rights is, my lord, IA number 8. I'm sorry, my lord, for the little inconvenience caused to the court.
Definitely inconvenience.
Yes.
We could have, by this time, we would have seen the interim order. We would have already gone into that and decided it. 3 IA number?
IA number 9 is, my lord, for permitting me to record evidence through video conferencing.
Please come to IA number 6 first.
IA number 6, my lord, I have made a copy of IA number 6 at annexure C, my lord.
Please refer to the page number.
In page 31.
So I'm saying where is the impugned order?
Yes, impugned order, my lord, in annexure E 41, my lord, in page 41. My lord, I had claimed, my lord, I am staying at Mumbai. I am the wife. I am staying with Mumbai with my parents and the child. Respondent is staying at Bangalore.
Court had granted 20,000.
Please, my lord.
How much was sought? 1 lakh.
80,000 per month was sought, my lord, under different heads.
So please come to the order where the discussion starts.
Yes, discussion, my lord.
Come to paragraph number 9.
Yes. Page 47.
Yes.
According to the petitioner, she is looking after her son and the respondent has neglected to maintain him. It is her specific contention that every year she is spending more than 1,50,000 towards the educational expenses, 25,000 towards extracurricular activities of her son. It is also her contention that her take-home was a housing loan. My lord, a joint purchase is made, my lord, in respect of flat, of which EMI is being paid by her only. In para number 3 of her affidavit, she
How much is the EMI?
EMI is 35,000, my lord, per month.
What is her income?
Her income is, my lord, 85,000 per month, my lord. But in the statement of assets and liabilities, my lord, it's 1 lakh. It's 1 lakh, my lord.
So then 1 lakh.
Yes. So she has stated, my lord, she has to also pay the rent in Mumbai. And under different heads, my lord, it was sought, my lord, on 80,000 rupees. Trial court, my lord, has awarded, family court has awarded, my lord, 30,000 per month, out of which, my lord, 10,000 to be borne by the petitioner and 20,000 by the respondent.
How much is the income of the husband?
My lord, that is state, that
92,000, Lord.
Huh?
Total income 92,000. I have filed my
92,000?
detailed
No, it
objection.
says, if I come to para number 16,
yes, my lord,
it says 17,08,733.
yes.
Yearly.
That's what we look at. You have to split it per month.
My-
How much it comes?
My lord, divided by 12,
My statement of objection, my lord, in that I have
it
produced.
will come
this,
to 1,42,000, my lord, per month.
No, my lord, it is, his salary is 95,000 in, I have produced, my lord, page number 11 in my objection statement.
Where are the objections?
Separately detailed objection with the records I have filed, my lord. She is placed
1,28,139 is your salary.
92,770 only.
What is it at page number 11?
Annexure R2, my lord, is my salary certificate.
It says 1,28,139.
Yes, but take home is 92,000.
Why?
Last sentence, my lord.
Voluntary
There are
PF.
deductions and I have to pay my EMI also, my lord. It is not that she alone paying. We have a property in joint account.
Please listen. Provident fund 6,237. Voluntary PF another 14,000. That itself 20,000 is going. Income tax 12,000. That is the deduction we can understand.
Last it is mentioned, my lord.
What is what extra? Huh?
My take home, last it is mentioned, last sentence in words and also in figure. Hers is more than mine. She is taking home 95. I am taking only 92 and she is the only child of her parents. She has a landed property worth 6.5 crores, Lord. And there is a house in our joint account.
Here, has she sought maintenance for herself?
Lord.
Has she sought maintenance for herself?
No,
No, she is earning.
She sought it for the child.
Yes.
So when
And
she has
the court has ordered,
if you let me complete, you can understand what I'm asking.
Yes, ma'am.
If you do not let me complete, then how will you understand what is the question
Yes,
I'm
ma'am.
asking?
Please, sorry, sir.
Now, she is asking for the son.
Yes.
Whether the grandfather is, what are the properties of the grandfather, what are the properties of the grandmother, they are not relevant. What is relevant here is, for the child's, maintenance, from your income, how much you are liable to pay. That's the only thing. Your take home salary according to you is 92,000. Her take home salary is 98,000. So from that 92,000 and from her 98,000, how much both of you are supposed to contribute equally?
I am contributing the 20. I am asked to directed to contribute 20 and she 10,000. Yes, my lord. That is the order. And on that 20,000 she has come here.
So 20,000 and she will be contributing with 30,000,
10,000.
10,000.
Totally 30.
It is 30,000.
30,000.
30. 20 from me, 10 from mother.
Then that is sufficient.
That is not sufficient is
child
my point,
alone.
my lord. Submission. Your lordship may marginally enhance.
Hmm.
In Mumbai, my lord, it's very expensive. I have stated, my lord, under different heads, what are the expenses I'm spending on the child.
What is the school fees?
My lord, I have stated everything in the affidavit. Even annexure, see, my lord, affidavit. School fees is 80,000 rupees per month, per annum, my lord.
That means how much per month?
It
It will
will-
be around 7,000.
Yes.
Hmm.
And uniform and shoes, 20,000 rupees. Uniform and shoes, the school charges 20,000.
Mm.
School books 20,000. School transport 30,000
Hmm.
Per annum.
per annum.
Hmm.
And on extracurricular activities of the school, my lord, they are charging 25,000 rupees, my lord.
Hmm.
And she has said about purchase of one piano, my lord. Your lordship may skip.
All those things.
All
will
the,
not
yes,
consider.
madam. I don't say.
Hmm.
Now, my lord, she has stated about herself, my lord, para 4, that her take-home salary is 85,000, and she is paying EMI of rupees 21,000 per month at a house, my lord, purchased in Bengaluru, and she has to, my lord, her expenses for cab to the office is, my lord,
It's all not required
Yes,
to be
yes.
looked into.
yes, and 20,000 for her food and clothing she required, my lord. So your marginally your lordship may enhance, my lord. She is still staying with her parents at Mumbai along with the child. Respondent is in Bangalore.
Proportionately granted.
Yes, yes.
It comes proportionately granted. It comes to 21,000 per month. His expenses.
Yes,
Already 20,000 is already directed by the husband to pay.
20,000.
It is coming to 21,000.
Yes,
If you calculate everything,
yes,
and per month it would come to 21,000. Already husband is asked to pay because anyway you are also equally earning.
yes.
So if it is your contribution is 10,000, his contribution here without order.
Yeah, yes, in that event, my lord.
Then next come to IA number 8.
No, your lordship, my lord, application for maintenance is, my lord, November 2022.
Hmm.
It should have been from the date of application, my lord.
What did the court say?
Court says from the date of order.
For what reason?
Doesn't say anything, my lord.
Then that is from the date of application.
Yes, from 1/1/2023 it says. It should be from November 2022, my lord. Your lordship may modify it.
One submission on that. The boy was with the father and mother here in Bangalore. Abruptly, she took the child, taking the.
That is a different aspect.
Yes.
Let's come to IA number 8.
For 3
Yes.
months, only for 3 months she went.
IA number?
to Bombay, saying that she will get another job there and come back after 3 months. She took the child, even the child she took and she started.
Yes.
IA number 8. Where
IA
is it?
number 8, my lord, for visitation rights filed by the
Where is that?
IA number 8 is 50, ink page 54, my lord, annexure F
50?
54, annexure F. Lord, there,
I want you to show me the order. Where is the order?
annexure, ink page 70, my lord. 70. Order on IA 8. My lord, here, my lord, I am not attacking much on the operative portion, my lord, except, my lord, clause 1 and 2.
What is the difficulty with clause 1 and?
Clause 1 and 2, my lord, with regard to clarity. My lord, the child is having, my lord, acute asthma, my lord. It doesn't suit, my lord, to Bangalore. So,
In summer, Bangalore is not so cold that.
no, asthma patient, my lord, especially, child is having, my lord, acute asthma. So, I don't dispute, my lord,
How was he when he was in Bangalore? He was residing in Bangalore.
my lord, in 2018, they shifted.
If there were no disputes, you would be still residing in Bangalore. So those kind of things we cannot see. Father will take care of.
Yes.
So that also will not consider. IA number 8 is dismissed.
IA number 8, your lordship may kindly see, my lord. There is no clarity, my lord, in the order.
What clarity you want?
Clause 1, your lordship may kindly see, my lord. The respondent is entitled for interim custody of his son for a period of 15 days during summer vacations.
So what clarity you want?
Your
to
lordship may
clarify?
clarify it, my lord, my lord, that there will be ambiguity.
First 15 days we will say.
Yes,
If you want, we'll say for first 15 days.
yes, my lord, first
just-
15 days.
okay.
And at least, my lord, he could alone move, my lord, to Mumbai and have it.
Next,
Second one, my lord. Respondent is also entitled for the interim custody of his son for a period of 5 days, either during Christmas vacations or midterm vacations.
parties for Christians.
Christians,
So then we'll clarify it. It is Christmas.
Christmas.
Child should
Yes,
not be there
next
with the
three.
father.
Next is, my lord, my application under IA number 9.
That is also 9 AM to other clauses you are not concerned. Yes, no, please come to I number.
9.
Which page it is?
For recording my evidence, my lord, through video conference.
That is not possible. That is like several matters I have dismissed and I have passed an order on this also. The main witness cannot be examined through video conferencing. She has to come. The demeanor of witness and several other aspects are very important. And that to these kind of contesting matters, she has to.
Then your lordship may
So-
take, my lord, second matter.
IA number 9 also dismissed. Then give the next matter.
Please, my lord. Lord, this application is, my lord, here, the application for amendment of petition, my lord, is rejected.
Now let us see your application for amendment.
Yes,
Where is that?
page 33, annexure D.
33.
Yes. My lord, only affidavit evidence of PW1. Chief, my lord, is.
Where is
filed.
the affidavit in support of this?
Yes. In page 41,
Which year is the MC?
MC 2021,
When is this application filed?
2023.
What is the stage of the proceedings?
Proceedings, my lord, affidavit of PW1 for chief examination is filed.
Commencing of trial, my lord.
No,
Chief of
After
PW1.
commencing the trial.
PW1, affidavit, chief,
Whatever it is,
Yes, yes, yes.
framing of the issues itself is commencement of the trial.
Yes.
File commencement.
yes, yes,
Stage is chief of PW1.
yes,
So please read, let's see the affidavit. What did you say?
yes, in page 41. Para 2, my lord. I say that some facts were left out while filing of the petition and incorporation of those facts are very important to decide the case on hand. The behavior of the respondent towards his minor child is required to be added to in the petition. There have been some subsequent developments in this case, and even those facts are required to be added to the.
No, the difficulty is, so many things will take place during the course, after filing. Your cause of action for filing a particular petition is so and so. Whatever is required to be incorporated, you have incorporated. What happens, the suit or the proceedings runs for years together. In between, whatever that transpires.
No, it is not.
Everything has to be incorporated.
It is not in between. It is not in between, my lord, before the.
He said so. Look
That's
at it.
true, but the stage in which, my lord, only affidavit of evidence is filed.
What about that?
Yes.
Why is it no? You make out your case. You make out what is your cause of action for filing it. Whatever that has happened till
Yes.
now and whatever you have stated.
Now, to substantiate-
Those would be the,
My lord, to lead my evidence, my lord, fully all these things are.
that we will be diluting the whole
My lord,
purpose of amendment by that.
My lord,
Particularly in this matrimonial proceedings, so many things will transfer between the parties from the date of filing petition and subsequent dates. Even the other day also, one application of the similar nature has come. Have dismissed it because then there is no end for this litigation. So 101 things happen during the course of visitation, that and this. If everything has to be low, again by way of pleadings you do, again basing on the pleadings, everything has to be changed. That's not the purport of
my lord, the
the
Supreme
amendment.
Court has said, my lord, amendment should be liberally construed.
Construed.
Order,
But
my lord, despite there being a provision to order 6 rule 17, my lord,
purpose of amendment. Purpose of amendment is what?
I'll pass on the judgment, my lord, for
Please.
just for my satisfaction.
Only bits and pieces of.
I do
clarity
understand,
is
I do understand what is the scope of an pleadings and how it should be helpful to the parties. Not like you can't bring the subsequent pleadings. What is that after the trial has commenced, in spite of, you should say, the party who is filing the petition should say, in spite of due diligence, they could not bring certain facts to the notice of the court. Hence, they are filing this petition. No, All these facts were not in your knowledge as on the date of filing of the petition.
But my lord,
You want to incorporate
yes, yeah,
something
but
subsequently.
But the reason assigned by the family court for rejection of my application is, my lord, proviso to order 6 rule 17. That is
That's that I will clarify now, looking at these facts.
No, my lord, when your lordships are dismissing, my lord, writ petition, my lord, it doesn't matter much, my lord, whether your lordships clarifies or not.
Yes.
But the only thing is, my lord, having regard to the provision contained in.
No, court cannot, that's what the Supreme Court said, that you can't strictly, technically look at it.
Yes.
Substantial justice to the
Yes,
parties.
yes,
And
exactly.
This,
Yes, exactly.
That is the next part.
Yes.
First part is whether the amendment is necessary or not.
Yes.
What for your file, that is important.
Supreme Court said, my lord, aimed at preventing multiplicity or multiple avenues of litigation subsumed under the umbrella of undispute. That is the wording adopted by the Supreme Court. Here, the trial court. Paragraph number 17, my lord. Your lordships are aware of this judgment. I am not that, but.
No, I'm like, even if I'm aware, that's the duty of the advocate to bring it to the notice of the court. Everything under the sun, the judge need not, will not know and necessarily need not know. So that's not the problem.
But
I can understand. What is that endeavor you are trying to, but in the facts and circumstances.
Your lordship may even, my lord, now that for the proceedings from that day is stalled now. Now we have to begin. There is an interim order of stay. What I'm saying is,
I am not on the point of,
substantial justice will be done, my lord, if I am allowed. Subject to cost also, my lord, I may be put on terms also. I may be written.
Not at all that amendment, what you want to do now is not at all necessary for the dispute between the parties in a MC. The reason for filing an MC seeking divorce is altogether a different aspect.
I may be permitted to read para 17, my lord. The
17 of what?
Apex court judgment.
Yes.
Just for my satisfaction.
Yes.
I don't think it will work out.
But please read.
Any and all days in judicial process should be avoided and minimized to the largest extent possible and should generally be and are rightly frowned upon. However, not in all cases can delay determine the fate of the suit. The defendant submits that the time gap between the submitting the written statement of the suit and the presentation of the application seeking leave to amend is unexplained. If this argument of the defendant is accepted, the question of will shall remain undecided or at best will be decided with a great delay. The trial, which has admittedly already commenced, would be stalled by way of challenge to the framing of issues, which in turn would not be in consonance with the object of Order 6 Rule 17, which is aimed at preventing multiplicity of so and so. Keeping in view of the above, along with the fact that without determination of the question so and so, the party so and so, the amendment is allowed, the appeal is dismissed. The trial court shall decide all these issues, including the genuineness of the will, expeditiously. It stands clarified that discussion herein above is only in connection with the application under Order 6 Rule 17, and no opinion whatsoever has been expressed on the merits of the case. Here, my lord, the trial court had rejected application for amendment, which was reversed by the High Court and confirmed by the Supreme Court.
So now the date of orders are also different. 1 minute. IA number 6 is dated, order is dated.
Please, my lord.
IA number 6.
Which present writ petition, my lord.
Please come. WP number 22475. Agreed with orders passed in IA number 6, IA number 8, IA number 9, dated 7/7/2023, 10/7/2023, 26/8/2023. 2023. The wife is before this court. The MC number 494 of 2021 is filed by the wife seeking divorce. In that, she has filed I number 6 seeking interim maintenance. I number
my lord,
8.
he had also filed a counterclaim of restitution of conjugal rights.
Husband has filed the counterclaim seeking restitution of conjugal rights. I number 8 is filed seeking visitation rights. I number 9 is filed to record the evidence through video conferencing. The first coming to I number 6, first subheading I number 6.
Lord, it is cross-examination she has sought in the video conference. See, chief is over already.
I number 6. The wife had filed this IA seeking maintenance of an amount of rupees 80,000 for the maintenance of the child. The court by order impugned had granted an amount of rupees 20,000. Court had considered the take-home salary of both the parties. The take-home salary of the boy, for father, is 92,000. The take-home 92,000 and odd, and the take home salary of the mother is
95.
98,000 and odd. Considering that the court had directed the father to pay 20,000, the mother has has placed before the court what are the educational expenses. The the school fees is about 80,000. The extra for the school, for the shoes and the dress, 20,000. For the bus, it is 20,000, and 30,000 towards extracurricular. 30,000 for what?
25,000 for
30,000 for what?
extracurricular activities. of the
Activities,
child.
no.
30,000 transport,
20,000 for what? You give the date?
uniform and shoes.
20,000. Another 20,000?
No, my lord, 80,000 for school fees.
Yes.
20,000 is uniform and fees. School books 20,000,
School books 20,000, transport 30,000.
30,000.
25,000 extracurricular activities.
Yes.
And she also stated that she is having interest in piano.
And 10,000 my lord, additional quarterly fees. Once in
10,000 additional quarterly fees. The boy is interested in piano. She bought him a piano which is worth rupees 3,50,000.
50,000.
3,50,000. And it is submitted that she's paying the EMI for the flat, which was for the property which was purchased jointly. The court, considering all the aspects, had held that 20,000 is sufficient. Then counsel for the petitioner submits that the court had failed to grant, the wife is living in Mumbai along with the parents, and with their support she is able to take care of the child. In a city like Mumbai, the amount of 20,000 towards the maintenance would not be sufficient, as from the salary she has to take care of herself and she has to take care of the child. It is submitted that considering the income of the husband, the court ought to have granted a reasonable maintenance. Ought to have granted maintenance as sought for by the wife. Next parallel, and counsel appearing for the respondent husband submits that the court had, considering both the salaries, in fact, the court had held that the father has to pay 20,000, it is, and 10,000 by the mother. Already, court had the more amount is from the father, and even if all the amounts that are stated are calculated, still that would not, the amount would not be, the court had proportionally awarded the amount considering the maintenance, curricular and extracurricular activities, and there is no interference called for with the order passed by the family court. Next para. Having heard the counsels on either side, peruse the material on record. This court has calculated the expenses that are stated by the wife, and approximately around 21,000 to 22,000 would be the expenses of the boy for month. The yearly expenses are calculated per month. Court has already directed the husband, father, to pay an amount of rupees 20,000. If, as both the parents are equally earning, if the 20,000 is like half of it is contributed, that is 10,000, and even another 10,000 is towards the other maintenance of the boy. In the considered opinion of the court had rightly considered the evidence on record and the requirements of the child, and rightly granted 20,000. And this court finds no reason.
My lord, it should be from the date of application.
Then
Court has granted from 1/1/2000.
Then counsel in his documents, then counsel the petitioner submits, the petitioner wife submits that when the maintenance is ordered, it should have been from the date of petition, but not from the date of order. But in this case, the court had ordered from the date of.
It is not even date of order. Date of order is 7/7/2023. Court says 1/1/2023. Application is made in November 2022.
The court had ordered it from
1/1/2023.
1/1/2023. Her contention, in her contentions, learned counsel for the respondent wife, husband submits that the wife without even informing, just like that taken the boy to Mumbai And from thereafter, she has failed to come back. And in those facts and circumstances, court had rightly passed an order from the date of the order. Next, in the discussion part, the court ought to, as far as granting the maintenance from the date of order is concerned, the court ought to have granted the maintenance from the date of petition, but not from the date of order. Accordingly, as far as I number 6 is concerned, the same is disposed of.
I had one submission, my lord, at this point. Right from the beginning, she has not given any visitation right. Only she is asking that the father has to pay the amount only.
The following.
And no visitation is
Accordingly,
allowed.
if the
So
visitation is
far,
not allowed, he will not pay the maintenance. IA number, accordingly, the following. See the difficulty of the court. Now, court has to pass on every IA one order. I think this is something, you send this file to chamber in the afternoon. IA number, I'll call the register judicial and we'll find out what it is. IA number 6, accordingly, IA number 6 is disposed of. Now we have to dispose of the writ petition or IA number 6? That's the difficulty now.
No, not both, my lord. Your lordship may modify order on IA number 6.
That's what I'm saying, like, it's so difficult. Then what would be the order in the writ petition? Accordingly, the order dated so and so in IA number 6, so and so is modified as far as the order of the family court in granting the maintenance from the date of order. It must be from the date of petition. Next.
Yes.
IA number 8 is filed by the father.
Visitation.
Seeking visitation, and the court by order dated 10th July 2023 has passed the following order. Look at page number 70. Extract that. Then counsel for the petitioner submits that the court ought not to have directed, as far as he submits that particularly the mother is agreed with clause number 1 and 2. Clause number 1 and 2, there is no clarity. And further, the boy is having asthma and the Bangalore weather is not suitable for him. Then in this clause number 2, it says as Christmas vacations or
No, clause number 1 first.
First I said already.
Yes.
first.
I'm sorry.
First vacations or midterm vacations. In that order also, there is no clarity. It is submitted that considering the boy's health, the court may direct the father to exercise the visitation at Mumbai itself, but the said order may be modified. Next parallel, counsel appearing for the respondent father submits that court, considering all that, had passed a reasoned order, and he cannot be expected to go to Mumbai for 15 days and exercise the visitation. Next para. This court heard the counsels and perused the order. The submission of the learned counsel for the mother that the boy is suffering from asthma and the weather in Bangalore
No
is
any
not suitable.
certificate to that effect. There is no any medical certificate. He did not have any problem.
Ultimately, order is in your favor.
Yes,
Why
ma'am.
unnecessary
No, that has
arguments
to be
were-
mentioned.
Why it has to be mentioned? That was not done before the trial court. And that is not relevant also here.
I'm sorry.
What did you write? Suitable for the child, that too in summer. This court is not able to appreciate the said submission. The boy born here and was brought up in Bangalore, and now because the boy is staying in Mumbai, it cannot be said that the weather in Bangalore is not suitable. As such, this court do not find any infirmity with the order passed by the family court. However, with regard to the clarification is concerned, the first 15 days of the summer holidays, the father can have the visitation, and when it comes to clause numbers 2, the father can exercise a visitation for 5 days during the Christmas first 5 days of the Christmas
vacation.
First 5 days of the Christmas
Yes.
vacation. Christmas vacation. Accordingly, the order accordingly this court is passing the following order. The order in IA number 8 is modified as follows, as far as clause number 1 and 2 is concerned, as follows. Now, whatever I've dictated earlier, 1 and 2 incorporate. Yes. Next, IA number 9.
Video conference.
Yes. IA number 9. IA number 9 is filed, agreed with the order dated 26th day of August 2023, whereby the court had dismissed the application filed by the wife, wherein she sought to examine and cross-examine herself through video conferencing. Then the court had dismissed the said application, observing that
Page 7.
that this is not a fit case to allow the wife to give her evidence through video conferencing. And the wife has not made out any grounds to exercise the discretion of the court in her favor and allow her to give evidence through video conferencing. The land counsel submits that as she's staying in Mumbai, the video conference, if the cross-examination is done through video conferencing, as we have the rules for the same, it would be convenient for the wife, and the court without any basis has dismissed. Land counsel appearing for the respondent with the kind of allegations that are made between the parties, unless and until the cross-examination is done before the court, there would be the lot of injustice would be caused to the husband. Next para, having got the counsels on either side, there is a material on record. Though there are video conferencing rules, and still there is a the parties or they can make an application for video conferencing. Generally, the main witnesses have to be examined in a normal course before the court. The Honorable Apex Court in Catena of cases has observed that demeanor of the witness is very important, and the court would be able to understand better if they're examined before the court. There are certain exceptional circumstances, and that too for an evidence of an expert and other witnesses, it could be through video conferencing. But when the prime witness, the witnesses were particularly in the matrimonial matters where the allegations are made against each other, in those cases, unless until a case is made out, there cannot be any order. In the considered opinion of the court had rightly dismissed the petition, and this court finds no reasons to interfere. Then WP number 25545 of 2023. Next, the agreed with the order passed in IA number 10 in MC number 494 of 2021, dated 7th October 2023, where an application filed under Order 6 Rule 17 by the wife came to be dismissed. The wife is before this court. The wife has filed the MC seeking divorce on the ground of cruelty.
Please, ma'am.
On the ground of cruelty.
Right.
Yes. In that, the MC is filed in the year 21. At the time of filing of the chief evidence affidavit by PW1, this present application is filed seeking to amend the pleading. As per the affidavit that is filed, the reasons affidavit that is filed in support of the IA, it is stated that some facts were left out while filing of the petition, and incorporation of those facts are very important to decide the case. The behavior of the respondent towards his minor child also is required to be added in the petition. There have been some subsequent developments in the case, and even those facts are required to be added to the petition, since all those facts have a significant bearing on the case. And mostly the significant facts that took place between the wife and the husband are required to be incorporated in this petition, and only on the basis of facts a court can decide a petition filed for divorce. Then when it comes to what she wanted to incorporate in this petition is certain facts were added to show that the husband used to continuously harass her and to nag her. Then in the other paragraph, she wanted to plead that how was the behavior of the child, how was the behavior of the father with the child. The trial court, the family court by order impugned. Where is the impugned order?
Impugned order.
Page
Annexure
not-
F, my lord, page 45.
By the order impugned, the family court had dismissed the petition. Submits that the learned counsel for the wife during his argument submits that earlier the counsel of the wife was different and recently he came on record. And after interaction with the wife, he came to know that several relevant incidents were not pleaded and he is constrained to file the present amendment application. The court has observed that that is not a ground to permit the parties to carry out the amendment, that too after the commencement of the trial. The court has observed that already the trial has commenced and the petitions are filed to bring the case under order 6 rule 17. The question of permitting the petition to carry out the amendment does not arise. And also the court has observed that it is necessary to keep in mind the hardship that will be caused to the husband if the present amendment is allowed. The wife has already disclosed, the husband has already disclosed his defense based on the earlier pleadings, and now several fresh allegations are being made against him in the proposed amendment, which would definitely affect his defense. After considering all these aspects, the court had dismissed the petition. Learned counsel for the petitioner submits that the whole purpose of the manner in which the order is passed by the court and the reasons that are given by the court are contrary to the purport of order 6 rule 17. It is submitted that in Caton of Judgments Honorable Supreme Court had observed that the courts cannot look at the amendments in a hyper-technical manner, and the court has to look at the substantial justice to the parties. And he relies on the judgment of the apex court in case of Dinesh Goyal alias Papu versus Suman Agarwal, within brackets Bindal and others, arising out of civil appeal number. A civil petition number, arising out of SLP civil number 30324 of 2019, the reported in 2024 INSC 726, and he has relied on paragraph number 17. Learned counsel submits that the court ought to have allowed the amendment. Next paragraph. Learned counsel appearing for the respondent submits that the court, without even considering submits that the court had considered the fact that the trial has commenced. Once the trial has commenced, it is for the petitioner to aver and prove that in spite of due diligence, these facts could not be brought to the notice of the court. In view of the amendment to Order 6 Rule 17, this amendment cannot be allowed, and the court had rightly dismissed the petition, and there are no grounds to interfere. Next, having heard the counsels on either side, there is a material on record. The MC is filed in the year 21. The amendment is sought at 23. The issues are framed. The matter is coming up for the chief affidavit of PW1. In all practical sense, the trial has commenced. Now, by way of incorporation, in the affidavit that is filed in support of the IA, it is stated that certain facts were not stated, and secondly, certain facts have happened after the commencement of during the pendency of the proceedings, which are relevant to be brought on record before the court. It is submitted by the counsel that the counsel, now the new counsel has filed the wakalat, and when he came to know certain facts were not pleaded, now by way of this amendment, all these things have to be, all those things they want to bring it on record. These are the two grounds. When an application is filed seeking amendment of the plaint, and the court has to look at whether why these particular facts and circumstances could not be brought on record at the earliest point of time. and what are the reasonable grounds for not bringing those? And if those facts are not brought on record, what would be the hardship caused to the party? As well, if at a belated stage, a particular application is filed seeking amendment of the pleadings, what is the impact of it? What is the impact of it on the other side? What prejudice would be caused? And any kind of admission that is made by the plaintiff is taken away by way of amendment. And the court has to always necessarily balance the interest of the parties. And at the same time, court cannot permit the parties for the purpose of dragging on the proceedings to come up with one application or the other. There is no dispute about the judgment, about the law that is laid down by the Honorable Apex Court in Dinesh Goel's case, alias Papu, referred to Supra. It has been consistently held by the Supreme Court in several judgments in a similar lines. The law has to be applied to the facts and circumstances of the case. Now, in the light of the law that is relied on by the learned counsel, and in the light of the settled law, applying it to the facts of the case, the reasons that are stated, why they wanted to incorporate, why they want to amend the pleadings cannot be a ground for this court to allow the petition. All the facts which were narrated, half of it were in the knowledge as on the date the pleadings were as on the date the petition was filed, and some of the pleadings now they by way of amendment which they want to incorporate is what have happened subsequent to the filing of the petition. In all these matrimonial proceedings, what all happened subsequent to the filing of the proceedings have to be permitted by way of an amendment to the pleadings, basing on a particular cause of action, a particular relief is sought, then there is no end to the litigation and no matrimonial proceedings can be decided. In view of the above discussion, this court is of the considered opinion the court had rightly considered and dismissed the application, and this court do not find any reasons to interfere. And accordingly, first writ petition is disposed of, second writ petition is dismissed.
Regarding visitation, Lord, right from the time she put the
No, I
child,
am
there
not
is no-
concerned with all that.
one sentence
Let
maybe.
us not escape, let us not, expand the scope of this petition. You have not even come
She is
before
not
the-
allowing the father to see the child and there is no physical touch at all. She has
What
not
did you do when it is not doing?
allowed.
When
We
this
went,
order is-
even taking a flight ticket, we went there, she did not allow me.
It is not about it. When somebody is not complying with the order, what did you do?
No, I was paying, will I have paid? And after that, he stopped because she
That
is
is the
not
only
allowing.
thing you can do. Father, if the court order is not complied with, what he is supposed to do? He will only go to Mumbai and come back
He went.
and tell before a court where an IA is pending to execute that order.
No, what she says is, it is there before the court, I will not allow you to see the child.
That's why you go to you ask the court that, her MC is pending. In that visitation order is passed. If she is not proceeding, if she is not obeying the order of the court, file a petition under 151 CPC, asking the court to stall the proceedings in her MC.
I'll do that, my lord. Obliged.
So now the court has to advise.
Cell number 2,
Yes, next.
Easier.
cell number 2, Ramesh R for petitioner, CG Malai for respondent.
This is a writ petition of 2024. The writ petition is filed.
Print the respondents.
You for the respondent.
Please.
This court on 12/7/2024 has passed an order. Interim order complied with
Non-compliant. Till date non-compliant.
and passed an order directing the husband to pay 10,000 per month and to clear off the arrears of 2,90,000. When the matter came up on 23/7/2025, learned counsel for the respondent submits that the petitioner has not complied with the interim order. No, show it to TS when you're filing for posting for dismissal. Where is the sentence that there is no representation for the petitioner? Show it to her, this order. And as there was no representation on behalf of the petitioner, the matter was directed to be listed for dismissal today. Today also there is no representation. The petitioner, having obtained an order from this court, had failed to comply with the order and had failed to appear before this court. Hence, the petition is dismissed for non-prosecution.
Cell number 3 for orders matter. Cell number 3, Pradeep B for petition. Appellant.
I will take steps, Your Lordship. One person is dead. I will take step. LRs has been already gone to.
No, why these matters have come before the court is, he said something like, he will file some application for dispensation or something he said. That's why they are listed today.
Because one person is, owner is dead. That's why we have taken the steps for the LRs. And also we have full amount has been deposited. Amount has been deposited as per the complaint.
That's how they are listed today. That's what he said yesterday.
That's why it has per the
Taking
record.
steps a week's time default order.
Yes, Your Lordship.
Cell number 4. SR
Your Lordship, I appear for the appellant in the first case. Appear for the appellant in the first case. I filed a wakalat, NOC wakalat. So 2 weeks time may be granted to take steps. Your Lordship.
When did you file the wakalat?
Day before yesterday, Your Lordships.
First time.
In-
2022
What is
MFA. Now even the process is not paid for the first time.
No, I'm filing the NOC wakalat, Your Lordship.
The
I came on
process shall
record.
It shall stand dismissed without further reference to the court in both second matter also.
No, other matter is respondent.
Huh?
4.1 is this.
Other matter I am respondent. It is insurance appeal.
Insurance company, yes, in 4.
2 days, sir.
Yes, 2
Cell
days
number
time
5.
for paying the process. Yes, 5.
Week's time, Your Lordship. So tomorrow is a holiday. Tomorrow is a holiday.
By Wednesday, it should be filed.
No, I'll take a paper publication, sir. Verify and take paper publication, Your Lordship. At least by Wednesday.
By 6/8,
Yes.
sir.
Yes.
Much.
Cell number 5.
Much.
Authorized K for petitioner or
Okay.
appellant. Cost paid.
No representation for dismissal on Thursday.
Cell number 6.
But I am for
Cell
claimant. 6, my lord, I am appellant in connected matter, my lord, I respondent in this case. But I preferred an IA for permitted to withdraw the amount deposited by the.
What about this third respondent is who?
He is the owner of.
You're paid.
Today
Counsel for the petitioner submits that the needful is done. Yes, what is that, Mr. Shastri?
My lord, it's a 2 death case, my lord. My lord, I was riding the motorbike, the vehicle car.
You're on what?
My lords, we are not liable in this case. The deceased was overtaking in the national highway. He dashed against our insured car from the backside and he fell down. The person was ran over by the KSRTC and the negligence part was not considered.
Immediately after service of notice on the third respondent.
My lord, another submission, madam. Another matter, you see, which is also connected with this 914 of 23. Madam, next week, madam, because accident is of the year 2018. Madam, my learned.
Service of notice, how can we take up, Mr. Shastri? Owner of the vehicle has to be served. Owner of the vehicle has to be served. Yes. So and so post along with this after service of notice to the third
Kindly
respondent.
connected with the 914 matter.
Yes, 914.
My presence may be noted. My
914
presence may be noted, my lord.
Yes, next.
My presence may be noted, my lord, because clients are.
The respondent, Mr. Shripadi Shastri, files an IA seeking for withdrawal of the amount. It is submitted, the land counsel for the petitioner opposes the same as they are on the liability. Hence, at this point of time, this court is not inclined to go consider the said IA. Yes.
Much obliged.
In which one?
6.2, in the same matter.
Memo is filed seeking dispensation of R2, dispensed with at the risk of appellant. Yes, 7.
7 is company appeal on negligence on the part of the deceased claimant. I already taken the steps last month. I don't know whether the office is sent to notice to the both the respondents. Kindly permit to serve the copy on the advocate on record before the tribunal place.
No.
Here they give this insufficient. They appear before the tribunal.
1 minute. Now, notice R2 is the owner of the vehicle.
Owner and both you please.
Huh?
Owner of the vehicle.
Owner of the vehicle.
Please.
Like insurance company is liable or not liable?
Not liable. There is no negligence on the part of our insured vehicle.
But if it's only or on the point of negligence.
Negligence.
But why is the notice to owner necessary now? Your policy is there.
The policy is there. There is no contributor negligence. There is absolute negligence on the part of the.
For that, owner presence is not required. Owner presence is not required. Why don't you file a dispense with petition for R3 so that it can be decided?
Notice, please. I will take out the notice, please. I will serve the. They are appear before the tribunal. They are because here they come the insufficient address. What is it?
No, in all the cases.
I can understand. There is only simply negligence on the part of the deceased.
On the part of the deceased, that only will be decided in this appeal.
Then I filed the memo for dispensation on the registered please, in both the cases. In the both the cases.
Please do it. When can you do it? You can give it now also.
I will try it.
Is this matter?
Weeks time. Next week I'm ready for disposal.
Is this matter on Thursday?
In 7.1, I filed application for withdrawal amount.
Withdrawal of the amount.
7.1.
Let him file a memo for dispensation. We'll hear it on that day and we will pass the orders on the day.
I'm ready for disposal.
Thursday.
7.3, 7.4 my connected matters.
Yes, on Thursday itself we will hear. Next Thursday, are you understanding or not what the court is saying?
7-8.
Some copy of business are there. I will
compare with.
I will compare.
Let them furnish both the appeal memos so they can file the contact our office and file the wakalat, please. In their appeals, let them give the copy right now, please.
I
will serve, sir. His address is there.
In 7.2 and calls for the
And
petition.
one more humble submission, it requires a TCR, please.
Call for the DCR. List this matter after 2 weeks.
Please.
So call for the
I'm ready for
DCR.
disposal on that day.
Yes. And in the meanwhile, all office objections shall be complied with, or else the appeals shall stand dismissed without further reference to the court.
Cell number 8. Reader K. Rectification officer.
Petition. The respondent file the memo.
What is this SOV?
He does not comply the order passed by this honorable court. May I submit, my lord?
Statement of objections are served?
May I submit, my lord?
Huh?
May I submit, my lord, in this case?
No. Statement of objections you have served on him.
Beg your pardon?
Your statement of objections, a copy is served on him.
No.
That is what is the office objection.
Rectification of officer will raise the.
Then counsel for the respondent should serve the copy of the objections on the counsel for the petitioner. List this matter.
Kindly peruse the last data order, please. Even there is a clear order passed by this direction.
Matter finally on
May I submit, my
6th
lord?
of August.
Just one submission, my lord. Order was passed on 2022 along with the maintenance. 10,000 per person, 3 son, daughter and wife. He never paid that amount. On the same day, order was passed for visitation rights. He wanted custody of the children. The court held an in camera and found out from the children that children were not inclined. That was the matter. From 2022 onward till the last hearing, no complaint. No complaint. What happened, my lord? On 22/11/24.
Please understand.
Hello,
Under what stage the matter is coming.
Okay.
On the last occasion, I have asked you to serve the objection.
I'll
Today also you won't serve. If you don't serve, why should I hear on the merits of the
I
matter?
will serve the copy. One submission, my lord.
No submissions. We'll hear everything at a go.
6,80,000 is due, my
This
lord.
matter on 6th of August by the petitioner, the respondent shall serve the copy of the objections today itself. Yes.
Cell number 9. Gautam Raghunath.
Yes,
May I
next.
request, my lord, 7th, my lord, this other case, 6th, 7th, my lord, please.
When do you want?
7th.
Seventh. Yes. Yes, 9.
I've served the
Cell number
copy
9.
to the respondent in family court. I'm filing the acknowledgement. Hand summons were issued by your lordships on 17/2/2025. She in fact appeared on that day before the family court for cross-examination, my lords, and I've served a copy. Page number 2.
The respond as per the order is to the respondent or counsel?
Counsel as well as the respondent, we've served it to the respondent.
As per the order passed by this court,
17 to 25.
it is submitted by the counsel that he has served the copy hand summons on 11/4/2025. On 11/4/2025 and filed an acknowledgement before this court. Considering the memo is taken on record, in lieu of the same, the notice to respondent is held sufficient.
My lords,
This is-
the only reason why I,
List this matter on Monday
please,
for print the name of the party. List this matter on Tuesday for preliminary hearing, for big group hearing.
great, so blessed.
Yes, 10.
Cell number 10, Geeta Devi MP.
List the matter after service of notice.
Lord, your lordship are directed to take a notice, my lord. So they copy to the council. That is Itisha Chopra.
Filed a memo along with
My
acknowledgement.
lords, I'm not aware that the matter was listed. I have received the copy. I'll have to.
So and so, Mr. Gautam Raghunath submits that he has instructions to file wakalat in
Please,
this
please.
matter. List this matter
I would require 10 days. time.
on Thursday. No objections in all this. You
No,
can
my lords,
come.
I'll have to get the wakalat from Bombay, that being the reason.
Bombay.
He lives in
Then
Bombay.
list the matter on 13th of August.
Great.
Please oblige.
Yes.
Cell
Print the
number,
name of Mr. Gautam Raghunath. Yes, next.
cell number 11,
That's I.
Well, I am for, well, I am for appellant. Well, I filed an IA for return of TCR. When I gone through the records, my lord,
25 is filed seeking to return of the TCR for withdrawing the amount.
Yes.
For withdrawing the amount and accordingly ordered. I number 1 is ordered.
cell number 12. Cell number 12, Harish Bhandari.
Case, your lordship.
No insurance company in this.
No, it's not.
This is RPFC.
It's an RPFC, yes. All are served.
Served unrepresented, your lordship.
I number 1 of 22 is filed to condone the delay of 179 days in filing. For the notice to R2 is
Held sufficient.
held sufficient by order dated 18/7/2025. Considering the reasons stated, the delay is condoned. List this matter for big group. Yes, next.
Cell number
On
13.
listed on 6th of August. Yes, next 13.
13, BP
Delay
Sidramaya.
of 132 days in filing revision.
Where is the respondent?
Sheila K.
Served 100%.
Sheila K. No, deemed service. IA number 1 of 23 is filed to condone the delay of 132 days. Same. Notice to the respondent is held to a deemed service of notice by order dated 87/2025. Accordingly, for the reasons stated, the delay is condoned. Same on the same date for P group.
Yes.
Cell
Yes,
number
next.
14. Vishwanath Sabrat.
Delay of 18 days. in-
Notice to R1 is deemed to be, yes,
Yes.
same order. This 18. Notice is deemed service of notice on 18/7/25. This also on the same day for big group hearing. Yes.
16. Cell number 15. Cell number 15.
My lords, in this matter at
Industry.
15. My lords, I had filed an IA for early hearing.
You appear for the petitioner.
I responded, my lord, for the
You
petition.
filed the, yes.
They have filed an earlier.
2023 matter. Yes, list this matter on Tuesday. IA number 1 of 25 is filed for early hearing. Ordered, list the matter on Tuesday.
Number 16.
Lord, I'm appearing for petition in this matter, my lord.
Ajay Prabhu.
Yes.
My lord,
Let him withdraw.
my lord, may I make submission, my lord. My lord, this petition has become infructuous. First submission, my lord. Because, my lord, this honorable court on 10/1/2024 had granted the interim order. My lord, interim order in terms of LOC, my lord. My lord, in spite of my lord notice and my lord, in spite of producing the order before the trial court, the interim order was not honored, my lord. Now
So
they
it
are
becomes
coming.
infructuous.
You know, it
Why
has
it
become
becomes
infructuous,
infructuous?
but I'm bringing to the notice of the court that, my lord, nobody had honored, my lord, the order of this honorable court.
So,
My lord, he is still in, my lord, my lord, abroad. He couldn't come to India.
What is the order?
It is a LOC issued against the petitioner for non-payment. The outstanding after depositing of 5 lakhs, outstanding amount was 44,000 only, my lord.
Where is the impugned order?
Annexure A, my lord.
Where is the order granted by this court?
My lord, 10/1/2024.
There shall be an interim order of stay paid for subject to the condition that the petitioner would deposit 5 lakh before this court. Then where is the LOC, what all you are referring to?
My lord, LOC is issued in terms of the impugned order. LOC was issued by the trial court. My lord, this honorable court had granted me the interim order subject to deposit of 5 lakhs. When this order was produced before the trial court, my lord, trial court did not, my lord, recall the order.
Why would
of
it
LOC.
recall the order? There cannot be further proceedings to recall the order.
Yes,
Once
my lord.
that order is stayed, it is stayed. Why would the trial court will recall the order?
My lord, it is a general assumption is that it is stayed. But my lord, it was not honored.
By whom?
By officials as well as the trial court.
What should the trial court do? That you tell the court.
My lord, the officials, when the officials has not, my lord, honored the the order of this honorable court, we have gone before the trial court.
How can you go before the trial court? Order is passed by this court.
This honorable court, but my lord, they have not honored. We have just, my lord, submitted before trial court that it is not honored.
What would the trial court do?
Anyway, my lord, I'm just saying that, my lord,
Yes, the IA number so and so of 25 is filed as per
matter
withdrawal
said,
of
matter can be my lord, dismissed as infructuous.
IA number 1 of 24. It's filed seeking to withdraw the amount. The petition is permitted, the respondent is permitted to withdraw. It is submitted that already the order that is passed, that is impugned in this is recalled. 12/6/2024, and the writ petition becomes infructuous, dismissed as infructuous. Yes, 17.
Till number 17.
For the petitioner, my lord. This matter has been resolved. I'm filing a memo, my lord. The mediator wants it to be recorded in the MC case. So the MC case may be called before the mediation cell tomorrow. They wanted an order from the court, my lord. I'm filing a memo. Which are the 3 cases to be placed before the mediation center?
Take that. Joint memo is filed before this court, whereby
Given the 3 specific numbers, my lord, those 3 matters before mediation center tomorrow.
Whereby the parties want to, on the terms and conditions enumerated in the joint memo, the parties want to withdraw MC number 4871 of 2022, execution case number 139 of 2025, execution case number 121 of 2024. Only the 3. 24. In the light of the joint memo filed before this court, all
Parties should be present.
All the 3 writ petitions are dismissed, and the parties shall appear before the mediation center for
That memorandum also kept below, my lord. What is the memorandum which is also kept?
before the mediation center for recording the compromise.
Humble submission, Your Honor. I'm ready for the, Your Honor, it's just not a joint memo. It's a memo file of copy what I've just now received a minute back. It's, Your Honor. Yes, Your Honor. It's just as it is recorded, it's not a joint memo, Your Honor. The copy I have received just a minute back when he was coming down to the.
I gave it to him just now, my lord.
Pass over. Look at it, sign it and give, then we'll.
Let him make a submission, that I'll accept it. If there's anything wrong in the memo, I'll accept it. Let him see it.
That's a whole difficulty now. They will not believe anybody. Yes, pass over, look at it. Not pass over, I'll take it up at next half an hour. Come back within half an hour. Yes.
Serial number 18.
For the respondent's case, your lordship.
Appear for the petitioner husband, madam.
For the wife, your lordships.
I have submitted. And for the husband, the order of 125 CRPC has been challenged. Interim order has been challenged.
Where is the order?
Let me reiterate, my lord. Before this order, this matter was again remanded back by this honorable court earlier, my lord. If I may take your lordships to the earlier order, which is at 102, annexure L, my lord. Page number 102.
Yes.
This order came to be passed on 10/1/2024, my lord. This
10/1/2024,
where this order was challenged before this honorable court on the ground that bank statements were not produced.
Where is the order of this court?
In page number
200, my lord.
159, my lord.
What was the order then?
This honorable court remanded back the matter to the trial court and ordered me to pay a sum of rupees 20,000 from the date of IA. The date of IA is 31 July 2022.
The order impugned in IA number so and so is set aside. The matter is remanded back. The trial court strictly in compliance with the law, apex code in case of so and so, shall pass a reasoned order. Thus, husband shall continue to pay monthly maintenance of an amount of rupees 20,000 per month.
Please.
And he shall file a memo before the trial court about how much amount he has paid. If any amount is pending from the date of petition till today at rupees 20,000, it shall be deposited within 1 month from the date of receipt of the copy of this order, or else the defense of the husband shall be struck off. He shall continue to pay an amount of rupees 20,000 till the IA is decided. The application shall be decided by trial court within a period of 3 months from the date of receipt of the copy of the order. Both parties shall cooperate and unnecessary adjournments. All the family costs so and so.
So, even that amount has not been
finished. Again, the matter was remanded back to the trial court. And the trial court passed a fresh order, which is at page number 174, my lord.
So whether the conditions that are enumerated in that order are complied with?
No, my lord. Still 1,52,000 is pending, your lordships. As per this order.
Then why did the court hear him?
Let me finish. Now, my lord, the date of IA is July 2022, my lord. Kindly see page number 175. The first paragraph, my lord. After remanding the matter, the petitioner has furnished a fresh assets and liabilities with bank statement commencing from July 2022 to February 2025. When Rajneesh versus Neha says the date of IA is July 2022.
We'll not go into that.
Please.
First of all, what is the order of remand by this court? Whether there is compliance of the conditions.
No, my lord. No order has been complained.
Let him complain.
I filed a memo of calculation, my lord, on page number on 8th of July 2025. May kindly be taken.
How was it considered by the family court? When there is a direction by this court, before dealing with your case, the court should have decided, whether compliance is there or not. Then an order.
That is the whole grievance, my lord. The amount what is paid by me is recorded in the order sheet, but it's not recorded in the impugned order, my lord. My lord, kindly see.
Deny the fact that 1,75,000 is due.
No, not 1,75,000 is pending. I filed a memo of calculation.
How much according to you?
1,04,000, my lord.
If 1,04,000 is
that, I'll comply, my lord, within a week.
Why? That has to be complied even before the order is passed.
No, that's been missed out by oversight, my lord. I'll comply. I've even told my
First of all, pay the amount, we'll see. Very interim order is there in this.
No interim order, lord.
The petitioner shall, while remanding the matter, the court has passed an order that the petitioner shall pay the arrears at 20,000. If the arrears are not paid, the defense of the petitioner shall be strike off. But according to the counsel for the respondent, the arrears are 1,52,000. According to the counsel appearing for the petitioner husband, the arrears are
1,04,000.
1,04,000. By list this matter on 11th of August. By
11th of August will be to a short period, but not any.
August, if this amount is not paid by that day, the writ petition will not be heard by this court, and it would be dismissed alone on that ground. List the matter on that.
If I may submit, I'll not take much of your lordship's time. This 1,04,000, I'll have my persuade my client. I'll have it paid, my lord. It's not the problem, my lord. When the order says, when the honorable apex court says the bank statements has to be produced 3 years.
Party who is at fault cannot point out at what is otherwise wrong.
No, my lord.
Now, when I have passed an order, When you have failed to come, first of all, the court ought not to have passed this order at all. First of all, the court would have insisted you to comply with the order.
Well, let me finish.
No,
She's come before the court.
Only after you pay the amount, I will hear any of on the merits.
If I may, if this may taken place before 11th of August, I'll pay half of it.
No, my lord.
All these amounts should have been paid long back. No more
I'll
time.
persuade my client.
It is calculated
Let him
20,000,
do.
your lordships.
Don't worry. If he is not doing, I'll dismiss the writ petition on that ground. Yes.
Cell number 19, Santosh Raj arrest.
Here for petitioners, my lords. The wife and the child's petition, my lords.
What was on why it is adjourned on the last occasion? It's not heard.
No, my lords, notice has to be, and it has to be connected with one more writ petition, my lord.
List along with,
20636.
write on a paper and give
Yes.
them, list along with so and so, when,
And summons may be taken out.
when,
My lords,
when do you want?
next week, my lords.
List this matter on 6th of August, along with so and so. The petition is permitted to take out hand summons of the counsel appearing for the respondent for the trial court. No, in that matter is filed by whom? Another writ petition?
Same by us.
There the respondent is served.
No, my lords, we have to take both the summons. My lords, it was listed 2 days back, my lords. That's all.
That's why hand summons ordered.
That is also ordered, my lords.
That's why this looking at permission to appoint mother as guardian.
Yes, my lords.
That's why I'm thinking I heard this matter.
Yes, my
It's a
lords.
different matter heard.
Yes, my lords. 2 orders are challenged.
Yes, next.
Cell number 20, preliminary hearing, cell number 20.
Appearing for the
Aditya.
appearing for the petitioner, my lordship.
Hmm.
The husband is challenging the maintenance award amount of 5,000, my lordship, to the wife.
Let's see. See the order. Here is the order.
Order at Annexure D, my lordship. Sorry, my Annexure E, my lordship. It's in Kannada.
It's in Kannada.
Yes, my lordship.
So what is the financial capacity of the husband?
My lordship, he was an agriculturalist.
How much is earning?
He was agricultural coolie. He was not earning.
Let's say agricultural coolie at least will earn 15,000 per month.
No, my lordship, 10,000. His age-old mother is there. She is a wife. Respondent is a nursing qualified nurse.
The petitioner shall file the translated copy of the impugned order. This is matter on 20th of August. By the time the translated copy is not filed, the petition shall stand dismissed without further reference to the court.
Cell number
Yes, 21.
21.
The husband's petition
Yes.
against the maintenance. The wife is a double graduate, MSc.
Where
They
is
don't
Mr.
have-
Ganesh? Heard the counsel for the petitioner, no representation for the respondent. List this matter on Wednesday.
Great.
5.
Yes.
Cell number 20. Cell number 22, GJ Sumkapur.
For petitioner, madam. Petitioner is the husband, madam. Petitioner filed the one MC petition for divorce, madam.
How much is granted?
10,000 is granted,
What
madam.
is your income?
Income is not in dispute, madam.
What is the
She is also having a teacher profession, madam. The only gist, madam, she is in adultery, madam.
That
That's
cannot
one,
be
madam.
decided in a criminal miscellaneous.
The matter can be referred for mediation, madam. if the parties-
No, the MC is pending.
Pending, madam.
MC,
She also filed a restitution of conjugal rights, madam.
Correct.
I filed the divorce
no,
petition.
this is filed in 2024. You're talking about adultery and all. We will dismiss this petition. Before the MC, you can ask for referring the matter to mediation. That's the only ground. It's nothing about the financial, husband is financially capable.
Please,
If
madam.
not,
Please, madam.
then adultery and all other things cannot be decided in MC, in a criminal miscellaneous. So if you want the matter to be referred, your MC is pending before the court. Seek there for reference to the mediation, not before this court. Please come. The present writ petition is filed. Agreed with the orders passed in I number 2 in MC number 1186 of 2019, dated 15th November 2023, whereby the court had granted maintenance of an amount of rupees 10,000 to the, where is that order?
62, madam. Page number. Okay.
In criminal miscellaneous number 826 of 2022, dated 3rd May 2024, whereby the court had granted maintenance of an amount of rupees 10,000. It is a case of the husband that wife is living in adultery. As such, she is not entitled for maintenance. The court had passed this order while granting maintenance to the wife. The court has observed that at this stage, there is no material to make out that the the wife is having illicit relationship, nor there is any document to make out that she has sufficient source of.
There is a material, my lord. ಮಕ್ಕಳೇ ಬಂದು ಹೇಳಿದ್ದಾರೆ ಅದು.
Still, it will not decide.
Children are in camera proceedings. We have said.
MC is pending that in that it will
It's
decide.
the observation made, my lord, that affects my.
I am reading the order of the court that is already made. Look at the order of the court at page 61. I am not making any observation of that nature. Any material document to make out that the wife is having illicit relationship, nor there is any document to make out that she has sufficient source of income. And at that stage, the court had granted maintenance of an amount of rupees 10,000. Learned counsel for the petitioner submits that there is enough material before the court to show that the wife is living in adultery. Learned counsel submits that when the wife is living in adultery, she is not entitled for maintenance. These aspects were not considered by the court. Next para. The husband has already filed MC seeking divorce on the ground of adultery.
Yes, madam.
On the ground of adultery, and the same is
Cruelty and adultery.
Cruelty and adultery, and the same is pending consideration. Wife had filed criminal miscellaneous seeking maintenance. In the criminal miscellaneous under 125 CRPC, the proceedings are summary in nature. In those proceedings, the court would not be deciding about the adultery or the other factors as that would be decided by way of a full-fledged trial in the pending MC. In that view of the matter, the court had passed an order granting maintenance of an amount of rupees 10,000 to the wife. In those circumstances, this court cannot find fault with the said order, and it is always open to the party to adjudicate all this in the pending MC. In that view of the matter, this court finds no reasons to interfere. Accordingly dismissed.
So number 23, Urmila Pullar, petitioner.
For the petitioner husband, my lord.
Yes.
I filed this petition challenging the award of interim maintenance granted under 125 CRPC.
Where is that?
At Annexure A, my lord, page 24.
How much is awarded?
20,000, my lord. In this.
What is your income?
No, my lord, I'll just make one submission. The DV court had already granted an award of 50,000 per month.
50.
Yes. Previous to this order. This is in addition to that. So total is 70,000.
So what is your income? That's what
income. Yes, my lord. I'm a doctor. Both of us are doctors. My monthly income I'm drawing as per my pay slip is 50,000. Hers is also 50,000, my lord. We are both Ayurvedic doctors. We have.
Let's see that finding. Where is that finding?
Yes, my lord.
Come to paragraph number 17.
Of the order, my lord.
Come to, I think, next paragraph, yes, 17. Where is that discussion of this? Next page. 45.
Yes, my lord. Yes, my lord.
Now, where is the discussion about the financial capacity of the parties?
My lord, the discussion is para 11, 12. My lordship will go to page 33. Onwards, it is there. On page 34, if you're
claiming maintenance only to herself or the daughter is
both there? The son. There's an autistic son. We have no problem paying for the son, my lord. And the only issue here is this exorbitant amount of 70,000. Because even though I have a clinic, she also has a clinic.
A general monthly expense of 1,60,000. It was also a deposit to the immediate effect.
And your lordship will see below. Further, it's also necessary to consider the fact that Udupi court has passed.
Respondent is having a salary of rupees 2 lakh per month and he is having 30 lakhs per month from his nursing home.
No, my lord. My payslip itself shows 49,800.
You're having your own hospital.
Clinic, she also has, my lord.
Where is the payslip for that again?
That is income, business income, no, my lord. That's variable income. So that can be, sometimes we earn 50, sometimes 1, 2, that sort of thing. But the point is,
No, sometimes you lack 50, sometimes you earn 2 lakhs. There is a lot
possible,
of
my lord.
variation. Then we will
So
look at
also-
2 lakhs what you're earning.
No, but she is also earning, my lord.
No. What about the child? What are the requirements? What did they state? Where is the statement of assets and liabilities?
Of the respondent.
The wife.
The wife, it's volume 2, my lord. I placed
Page
it.
number?
Page number 123 onwards.
Let's see.
At page 126, if your lordship.
Where are the expenditures of the dependent?
Page 126, my lord.
Let's see. The son of the deponent is suffering from receptive language disorder.
Yes.
With autistic features.
But I'm paying for the education as she's only admitted, my lord, in the bottom.
Let's see. Towards food, clothing and medical expenses, 60,000. Towards expenses for education, 10,000. Towards expenses, extracurricular, educational, vocational. Any autistic children, they need more money for all the therapies.
It's true, my lord. We are okay to pay for that. But why?
Okay for what? What okay for what?
To pay for the expenses of the child, my
But
lord.
first of all, you tell what are the expenses of the child.
As per her,
Being a
in
doctor, he
60,000.
also knows what he.
Exact amounts.
Forget about the wife.
Yes, my lord.
So she has to take care of the child, and she is also a doctor. That boy requires some attendant help and all. And apart from that, all the therapy classes he requires. And even the school also.
I'll seek instruction and produce a table exactly how much, because it's also variable.
Instructions by the next date of hearing and comes to the petition shall get instructions whether the amount that is awarded by the before in the domestic violence case is regularly paid by the husband or not. Second, she shall also get land council shall also get instruction what are all the requirements of the boy as stated before the as per the husband.
Till then, there may be a stay, my lord, on this order, please, because of that liability there.
If you want it tomorrow, I'll get it. I'll have it on Tuesday, but no stay.
Tuesday, okay, very well.
Is this matter on Tuesday?
Obliged.
24.
Case number 24.
For the petition, my lord. This is the petition filed by the husband. The trial court, the petition, the husband filed the application for visitation rights in a petition under section under guardian and ward act.
Dismissed?
Pardon?
It is dismissed?
It was returned with a to place in the proper court.
So you will come to the High Court?
Please. My humble submission, my lord. The husband.
How this writ petition is maintainable? Now, for example, our registry will return your documents to place it in a proper format. You will go to Supreme Court questioning that order? You will not. First of all, how the writ is maintainable? What is the difficulty? If you don't file it in the form of a format, they will return it. Against the return of a document, petition, can a writ petition be filed?
No, my lord, my submission. The wife filed the
Let's see what
divorce
is the
petition.
relief. Please, what is the relief that is sought?
Visitation rights.
Why should this court look into it?
Kindly come to the page number 49, madam.
I'll not go anything in.
Relevant portion.
This court is not exercising the original jurisdiction to pass orders. Of
My humble submission, my lord. The wife filed the divorce petition is pending before the Shimoga court. Thereafter, the husband filed the petition for guardian ward act. In that petition, he filed the application for.
I cannot go into any of the merits of the matter because this writ petition is not maintainable before this court. If the court returns it, you have to file it in the proper format. How can you come before the court? The present writ petition is filed.
No.
Seeking the following prayer. According to you, the court is having jurisdiction.
Yes, my lord. May I answer
Come
this?
to the impugned order.
Impugned order, page number 49, my lord, relevant. Para number 12, my lord. Undisputedly, the ward is currently studying in Davangere. And the petitioner has willing to consent to
Which
visit.
para you are reading?
Para number 12, page number 49, my lord.
Please read.
Undisputedly, the ward is currently studying in Davangere and the petitioner is willing to consent to visit the child at his location. This arrangement would not impose any inconvenience to the respondent when presenting the child before the court and would also conserve time and travel expenses.
Come to your petition, JNWC.
Page number 22 is the petition.
Page number?
22.
26.
20. 22, my lord.
22. In the entire petition, you have not said, you said that they are staying at Davangere, that is one point. At any point, from when he is residing at Davangere, you have not stated anything.
My lord, my humble submission, I am residing in the Davangere and wife also, she was there in the Davangere. Her petition is pending before the Davangere court.
Where is the boy now?
Boy is studying in Davangere. They filed the objection to my petition stating that now the boy is studying in Davangere, hence I shifted to Davangere. She stated in her objection.
Before which court you have filed this?
Same court, my lord. Shimoga court. Her petition is paid for divorce is pending before the Shimoga court. Page number 37, my lord, the objection of the respondent wife.
Where was the marriage taken place?
Marriage taken place in Dharmasthala, that is a temple.
Dharmasthala. Then where, in which place both of you have lived together?
Live together in Shivamogga, my lord. And
Till when both of you lived together in Shivamogga?
Yes, my lord.
Till what? Till which year?
2 years, they are separated from 2 years.
2 years
back.
is, that is 2022.
Yes, my lord.
Because 2022 separated. After separation, where is the child?
Child is now, they are taking contention that the child is.
Not now. Immediately after both of you are separated, where was the mother and the child were residing?
They were residing in Shivamogga, my lord.
Shivamogga.
The MC petition is filed where?
Shivamogga.
MC petition.
And the boy is residing in Shivamogga.
Please. Thereafter, after my filing the petition, they taken a contention that now he is studying in Davangere.
Then that will not become his ordinary place of residence. Because he has come to Shivamogga now, it would not become his ordinary place of residence. His ordinary place of residence is Shivamogga.
Yes, madam.
That's why the court said you have to go before the court at Shivamogga.
No, my lord. The petition filed in the Shivamogga. Why filed petition is pending for divorce, and I filed a petition in the Shivamogga court for.
Just for the education purpose, he went to Davangere.
Yes, my lord.
When was he went to Davangere?
1 year back, my lord.
So from the last 1 year, he is staying there. You filed the petition on 14th of 2024.
Yes, my lord.
What is he studying now?
He's studying 7th standard, I think.
Yes, notice to the respondent.
Already notice issued, my lord. The trial court advocate. I served the copy to. I served the copy to the trial court advocate.
Where is the memo?
Filed the memo.
You filed?
Yes.
The land counsel, the petitioner submits the RTS as per the order passed by this court. He has served the notice on the advocate by name T. Asha and file the acknowledgement. Print the name of the advocate. List this matter on Tuesday. Is 25.
Cell number 25.
For the petitioner, it's a seek for an adjournment. He plays on record the order sheet of the trial court. It may be listed next week, my lords.
Why?
Because the arguing counsel is not there today, my lords, due to the.
Why you want to place that?
My lords, we have challenged the 4 IAs, my lords, which we have filed before the trial court. And that particular, the filing of that application has not been recorded in the order sheet, my lords. We have not
The request of when do you want?
Next Monday itself, my lords.
Place this matter on 13th.
Cell number 26. Cell number 26.
Okay, for the petitioner.
Yes.
For the petition challenges the order of the family court refusing to stay a decree of mutual consent passed by the court, not insofar as the parties are concerned. The petitioner is Christian by religion and the respondent is Hindu. But they were married on 24th of February 2010 in accordance with Hindu rites. Thereafter, the marriage was not registered under the provisions, not solemnized under Special Marriages Act, or nor was there a church wedding. There was a son born from the marriage. 2018, they separated. And in 2021, they filed a petition for divorce by consent under the provisions of the Special Marriages Act. Though the marriage has not been solemnized under Special Marriages Act, the only document produced before the family court at the time of presenting the petition for divorce was a certificate of registration under the Haryana Compulsory Registration of Marriages Act. All states now have, most states have this Registration of Marriages Act. Under that act, that unfortunately, the family court has not perused that. And yes, by consent, we obtained a decree of divorce. Thereafter, there were certain developments that have taken place, because of which the petitioner wanted to seek modification of the decree. At that time, she was advised in July of this year that the marriage itself is invalid. So there's no question, when the decree is invalid, there's no question of modifying the decree. But this law is well settled, by the Honorable Supreme Court, that any decree
or any marriage between a Hindu and a Christian under the Hindu law.
No, but that cannot be used by the wife for her own convenience.
That
Someday when it was happy with her, she will take a mutual consent divorce.
But she was unaware, my lord, of the. In fact,
ultimately, under whatever provision it is taken, the intention of the parties is to put an end to the issue.
Correct.
And to get the benefit out of it. You got the benefit out of it. Now you wanted it, now you want for some reason to suit your convenience, you want it to be amended. Now you understood that law doesn't permit.
No, in fact, she wanted amendment of the decree. The advice she has received is that since the decree itself is invalid, there is no question of the decree getting amended because the marriage itself is invalid. This law is very well settled.
The law is settled.
Yes.
That is now, what is the intention of the parties?
What has happened is this. I must bring to your lordship's notice that subsequently she has remarried. Her relationship with the person where the marriage took place earlier also is cordial. There is a son from the marriage. She has relocated to Delhi. The son is staying with her in Delhi. Everything is fine, my lord. The dispute has arisen because in terms of the mutual consent decree, the custody was to be with the father, though in effect custody has been with the mother throughout. Now, because she has moved to Delhi and the son is living with her in Delhi, the father wants the child to be brought back to Bangalore and he wants to enforce the decree. But this is purely a technical aspect. If there was a possibility of seeking modification, we would have availed that opportunity. Unfortunately, there is no possibility of modifying the decree, considering the decree itself is invalid. The Honorable Supreme Court says, by consent, parties cannot confer jurisdiction.
That is generally that's the law.
Otherwise, there is no intent not to.
No, because that is advantageous for her now. Because now she wants to get out of that particular clause, and she wants to have the custody of the child.
Custody has been with her throughout.
No, whatever, but that is contrary to the terms of the decree.
Correct. Notwithstanding the terms of the decree, custody has been with her throughout. The difficulty is this: I cannot seek modification because the decree is invalid.
So you will seek for ways and means. How do you get out of it? It has come now. The legal advice is.
The only other way I can do is to challenge the decree, and thereafter file a petition for custody of the child. It will be a child out of wedlock, not from the wedlock. That unfortunately that is the situation we are faced with.
Notice the response.
That is what the family court has done. Notice the order challenged before your lordship.
When was the compromise decree?
Sorry.
When was the compromise
in
decree?
2021, my lord, on
2021.
Yes.
Something is going on till 2025.
Yes.
So why should we interfere with that now?
No, she was absolutely unaware that the decree itself is not valid.
What is if it is not stayed, what will happen?
But the father wants to enforce the decree, which is not a valid decree. I will be open to.
No, through that decree, what all you could get, you can have a marriage. Now your marriage is an invalid marriage.
It's a legal conundrum. We are faced with the situation.
Now, if we suspend this, now your marriage becomes an invalid marriage.
No, that marriage is invalid. My first marriage itself is invalid.
If you don't have a valid divorce,
yes,
and you marry for the second time, how would that be a valid marriage?
This my marriage to the respondent here itself is void. It is not recognized by law. That is the law, my lord, laid down by the Honorable Supreme Court.
Unless until it is declared.
We are not fighting shy of seeking modification.
But what I feel is court ordering notice was a right step. There can't be a stay.
The reason court orders notice is to verify whether they were not aware about Special Marriages Act.
It's not that. Let them come. Let both of you contest. You have mutually taken a divorce.
True, my lord.
No, mutually appearing before the court, that can be heard. No
But
stay.
may I make this request, my lord? Well, let notice be issued in this matter. Because date given now is 25th of September, 2 months later.
The hurry of the parties is not the concern of the court.
Child.
It's okay. 21st, from 21, this is happening. Now we are in 25, and September, giving the date in September is not wrong. How can the court decide?
But when I'm seeking an injunction, my lord, the application, I'm seeking the suit for declaration with an interim application to stay the decree is what I have sought, my lord.
If the court decided, I'm not.
May I make this request, my lord? If your lordship permits me to serve the notice on the other side.
Because why should we? The court will decide.
No,
Let the trial court decide in September. What happens?
The child's school admission is not done. The child doesn't want to come. Your lordship wants to interact with the child. We'll very well bring the child before your lordship. He's 11-year-old boy.
Because every matter can't be done by the court immediately.
I understand.
A lot of work for them.
But when the law.
And that too, a kind one of this nature.
Yes.
Where you're having you had your own fruits of enjoying the fruits of the decree from the last 21 to 25.
The relationship between the petitioner and the respondent remain cordial to date. It is not that we are fighting. We converse with each other on a daily basis. But we are faced with a situation, I am faced with a situation where I am not in a position to seek modification. Your lordship may kindly appreciate my difficulty.
I can understand, but I'm saying there is something that has to be interfered by this court from according to you, the trial court has not interfered. It has not interfered because the other side should come.
For the only reason I want to find out from him whether he was aware or not. I've gone on affidavit and stated, I am Christian, he is Hindu. That is not indisputable. We have stated that I have stated that
You can add interim injunction.
Sorry, Manu.
You're seeking an ad interim injunction.
Of stay of the decree is what I'm seeking.
Ultimately, that's
Yes,
what it is, without
true.
notice to the party.
True.
So because what is there in existence from 25, suddenly why should we interfere with it in 21 to 25?
When the court, is made aware of a fact that the decree is invalid, is non-est, because the party's marriage itself was invalid.
That can be done. That can be slowly, we can take it forward.
But the difficulty is that the child's future is now in jeopardy.
Mother
Because of the
understood
situation.
it after 5 years.
Sorry, Manu.
Mother understood it after 5 years.
No, because we were absolutely fine. I had not moved to Delhi. I had agreed to the child studying in Bangalore while I was living in Delhi. The child is refusing to come.
Then why did she agree for such a clause?
She was, at that point in time, my lord, they were staying in the same apartment. I've said it we were staying in the same apartment complex. Custody was virtually with me. He was only meeting the father for 1 day in a week.
So then
We have enough correspondence.
Consciously, mother accepted for such a clause where custody should be given to the father, and she didn't give it. And she enjoyed it as per the decree, contrary to the terms of the decree, she enjoyed. Now suddenly, she wants an order from the court. Why should the courts come to that?
I'm not trying to take an advantage, my lord, of what has happened. I am in a difficulty where I'm unable to seek modification of what decree has been passed.
So you sought on a technical ground that there is no jurisdiction or there is no marriage, it cannot be entertained. Court will decide it. But why should we grant interim injunction?
Because otherwise, makes only one request, the other side the notice may be issued.
It is like
the child will also come before the court.
Like something like bypassing the orders of what wrong the trial court has done that this court has.
I quite see that on the face of it, it looks like the mother is trying to take advantage of her own wrong.
No, if not advantage, but still this is not a case where the court has to straight away, first of all, the court see that whether it is whatever it is, but you have surrendered yourself to the jurisdiction of the court or had an order, enjoyed it for some time.
This is exactly what the Honorable Supreme Court says. Just one citation. By consent, I cannot confer jurisdiction.
What is that, Kiran, right,
1954. Yes.
From there, the judgment is there is, why is very clear, like parties cannot confer jurisdiction on the court. But these matrimonial cases, we are dealing with the lives of the people, but not the property.
True.
So just like that, there can't be an ad interim injunction.
I quite see. But the fact that I have brought to the notice of the family court that the marriage itself was invalid, and therefore, if the family court had at least perused, the marriage certificate, it would have been clear.
I'll go a step further. We will see. We'll find it from your pleadings that the marriage is invalid. Still, there is no reason to grant ad interim injunction. Because that is dealing with the life of the children also.
Very well.
So unless both parties are before the court understands what is the complication, what has to be done, then the court will do. In these kind of cases, even if the matter comes before me immediately, I wouldn't have not granted any order.
But granting 2 months time, it only the child's my only concern is that because I cannot even on merits, I cannot even tell the court that this is the problem I'm facing because I can't go beyond the decree. The decree is invalid. If I had an opportunity of filing any other proceeding, my lord, I would have filed it.
You know, for the father would have not raised this objection. You would have proceeded like assuming that decree is a valid decree.
That would be, my lord, being aware of something.
Nothing will happen. What will happen?
My lord,
The court will not say like this is invalid. Nobody will go into that aspect.
it would again be, my lord, making a submission on oath, which something that is not correct.
That's you already done once.
I was not aware, my lord. I've stated so. My lord, we are laymen. We are not aware of what the intricacies of law.
That's why we will see. I think let the trial court decide.
My lord, may make only one request, my lord. I'm sorry, I'm seeking a lordship indulgence in this matter. My lord, if notice issue to the other side, we are only looking at settling the child, my lord. Nothing else. Nothing else, my lord. It's only about the child's future. My lord, I'm also making the submission. When I moved to Delhi, I had told my son that he would be staying in Bangalore and continuing his studies in Bangalore.
Then why didn't she do it?
He is refusing, my lord. There is enough. In fact, I did not want, because since that is not germane to the issue involved in the writ petition or in the suit, I have not placed the material on record. I will place the material on record where the mother is telling the father, I have no objection for him to study in Bangalore, but he is refusing.
So then what will happen to the child now?
He is neither here nor there, my lord. That's the difficulty.
What is the legitimacy of the jail now?
No, under the
We want it to be declared now.
no, until the under the Hindu Marriage Act itself, legitimacy is protected. No, that is. I will continue as the natural guardian. Roxanne Sharma versus Arun Sharma, the Honorable Supreme Court has clarified that aspect about legitimacy. But I'm neither here nor there. That is my difficulty.
It's notice to respondent.
Lord, may I request a date? I'll take out emergent notice.
The matter on 14th of August.
May I take out emergent notice?
Yes.
Oblige. Grateful.
Case number 27. Anand B. Muddappa.
Yes.
Okay, for the petitioner. Husband, my lords. Husband, my lords, always on the back foot. On the lower pedestal pertaining to maintenance matters. This is a second round of litigation, second writ petition.
What is the impugned order?
Impugned order and actually, my lords, interim maintenance.
1,000 per month.
Before I apprise you about the interim maintenance order, my lords, certain facts, my lords, pertaining to the conduct of the parties. Both the parties are in their second marriage. They have a child from their first marriage. I am ready to pay maintenance, my lords. But she enters into the marriage, stays with me not even for 3 months. Intermittently for 3 months. It is an admitted fact. She was working prior to the marriage. I file a petition seeking for restitution of conjugal rights. She comes on record. She doesn't file objections. She files this application under which the impugned order is passed. She doesn't want to come back. I am ready to take her back. Then looking at her conduct, my lords, I file a petition seeking for divorce. In that she files objection. She doesn't even want divorce. Now, my lords, indulgence of this court would be required. I am ready to pay one-time settlement. I was ready to take her back. She's not ready to come back.
Then we'll order notice.
The notice, my lords, the impugned order may be stayed, my lords. My lords,
Can have only.
why, my lords, in the interest of equity, if the stay order is there, my lords, one-time settlement, it would facilitate a one-time settlement. My lords, from past 8 years, I've been harassed.
You pay whatever is supposed to pay. You pay. We'll order notice. Let her come. Then we will.
My lords,
we will see
let
what is to
them
be
seek
done.
for vacating of the stay, my lords. It would at least facilitate.
Will not grant any blanket order of that nature.
My lords, the impugned order, if I go on merits also, the assets and liabilities, my lords, I have shown
What
only
is the income of the husband?
25,000, my lords. He's a dentist, my lords.
Income is 25,000.
25.
What is he doing?
He's a dentist.
Dentist income is 25,000.
He's a mediocre dentist, my lords, running a small clinic.
She is also a dentist.
She is no, my lord. She's a BSc graduate. She was running a nursery prior to the marriage.
Maximum what the court can do is half of the amount. Land comes for the petition subject, sir.
Lords, now it is from date of application is 17, my lords, 2017. Now it's piled up to around 10.5 lakhs. And moreover, my lords,
Then comes for the petition submits that the income of the petition is 25,000. Court had granted maintenance of an amount of
15,000 per month.
1,000.
First it was 10,000, my lords. This court, by your order, only, my lords, it was remanded.
15,000. The court has awarded. It is submitted that the wife is also a graduate and she is capable of earning or earning.
Earning, my lords, and she has her income from a father, other sources
And
also.
the marriage and both of and this is a second marriage for both of them. and the marriage has lasted for 3 months. Considering the submission of the land council, there shall be stay of all further proceeding on the condition that the petitioner shall pay 5,000 by 5th of every succeeding month, and the arrears also at 5,000 from the date of petition till now. The same shall be deposited within a period of 8 weeks, or else a stay granted with this court stands vacated. Petition is permitted to serve hand summons on the counsel for the respondent and shall file a memo to that effect by 19th. If the memo is not filed, even on that ground, the stay stands vacated. Yes.
Obliged.
28. Number 28, Ravi Shankar Shastri.
Petitioner. My lord,
Yes.
husband's petition, my lord, as against grant of interim maintenance to the daughter, my lord, of aged 6 years.
6 years, how much
25,000 maintenance was awarded.
is
my
your
lord,
income?
interim maintenance.
income?
My lord, my income, my lord, the petition itself says, my lord, I was unemployed, and therefore she left the matrimonial house along with the child.
How the court has considered, come to that order.
Please, my lord.
Which court is this?
Para
Principal,
18,
fifth
my lord.
principal judge, family court.
Para 18, my lord. That would be the reasoning, my lord. The family court holds father is bound to
Oral obligation to look after his children.
look after his children, that on the perusal
Before
of,
that, no discussion
my lord,
about the salary and all.
my lord, about the what are the requirements of the parties, my lord, was discussed regarding it.
Petitioner have also sought for litigation, so and so.
My lord, here is a
What's
case.
happening to them?
My lord, here is a case, my lord, wife earns 1,50,000 as.
Show the court where is your financial capacity
Yes, my lord.
discussed.
My lord, and so far as the financial capacity is concerned, my lord, the family court does not, my lord, bring it to. Para 19, my lord, only
You file
says,
your statement of assessment.
I have, my lord, she also filed, my lord, annexure.
What is her income?
My lord, she claims, my lord, her income was 1,50,000 per month. She is working as a software engineer, my lord.
1,50,000.
50,000.
You said you are unemployed.
My lord, she said I am unemployed, but I have stated, my lord, I got the employment, my lord, in government, and I am earning rupees 50,000 per month. And out of that, I am paying EMI of rupees 40,000 towards the loan of house. And my lord, parents are with me is my difficulty, my lord.
How can you take, having a salary of 50,000, how can take a loan where you have to pay 40,000 as EMI?
My lord, father, myself, and my
No,
lord.
no, 40,000 EMI. So with
Yes.
10,000, how can anybody live? Even alone for you, it will be sufficient. That itself shows that for the purpose of evading maintenance, you have taken that loan.
My lord, petition averments, if my lord looks into, she herself says she was paying 30,000 EMI to the father-in-law for payment of EMI. That is her petition averment, my lord. She says entire family has misused her. She paid rupees 30,000 to father-in-law for payment of EMI. She paid amount to mother-in-law for buying of the gold ornaments. And her husband is unemployed and is avoiding to take any job.
When did you get the job?
My lord, my job, my lord, I got on 13/2/2024.
13 to
2024.
when was this MC filed?
MC was filed, my lord, on 2012/2023.
So with this 10,000, 3 people have to live. And what for what purpose you have taken the loan?
Housing loan, my lord.
And you
That
constructed a house.
yes, my lord. We are residing, father and mother family is residing therein. My lord, here is a case, my lord, where mother, my lord, she gets a annual monthly income of
What is
rupees
your contribution to the daughter or the son?
6 years age daughter, my lord.
Something is required.
25,000 is, my lord,
Is on the higher side.
not a
But
requirement.
even from what you say,
Yes.
10,000, what will the court, how 3 of you will live with 10,000?
My lord, myself, my lord.
Something is not,
My lord, I have
appears to be not
my lord,
correct. So
assets.
you have some other income apart from that.
My lord, father is having his pension, my lord, and that.
So you don't have to take care of the parents.
Yes, my lord.
Parents have their own income.
Yes. I am contributing for payment of EMI of housing loan, my lord, where I am residing along with my parents. But her petition averment also shows she had paid EMI of rupees 30,000
Please
per
come.
month.
When comes to the petition submission of the court is granted maintenance of an amount of rupees 25,000 to the daughter, and his income is 50,000. Out of that, 40,000 is paid towards EMI, and it's difficult for the father to pay.
He is
an amount of
contributing, my lord. There is no proof of payment. He says I am contributing.
How it should be? There should be.
Yes, my lord.
No, if you're
He
if you're
says
paying, if you're paying You're contributing means how are you contributing? You are a government employee. Your all your amount is
Yes.
that's in the bank.
Yes.
What is the outflow? To whom you are giving that?
He says, my lord, he was paying to the father for payment of EMI. That is his severment. I should be fair to the court. my lord.
It is that he is paying the EMI. He's contributing an amount of rupees 40,000 towards EMI, and he is left with no amount. The wife is earning 1 lakh.
50,000. my lord.
50,000. Where is the discussion of the court in this?
My lord,
About your 50,000?
regarding, my lord, my salary. My lord, the court, my lord, says para 14, my lord. At page 24, top portion, my lord. If really monthly income of the respondent is only rupees 50,000, nothing prevented him to produce his salary certificate or pay slip.
So
But annex Shariat I have produced statement.
40,000 he is contributing, considering the same. There shall be stay of all for this proceeding. 15,000. 15,000 and arrears at 15,000 by 5th of every succeeding month for paying arrears 8 weeks. Less this matter on no, by memo shall be filed by 20th of August. If the memo is not filed, then also the stay granted by this court stands vacated.
My lord, interment is may I seek for reduction, my lord. 15,000 may not be on. My
But
lord, wife funds, my
your
lord,
for the child you are giving.
my lord, child of 6 years, my lord. Her requirement, my lord, has to be considered.
School fees, how much you took?
My lord, she says, my lord, in a para 95,000 per annual fees, my lord.
1 lakh.
1 lakh per year.
5,000 for the school.
Yes, my lord. And she says for swimming class and the dance classes, she may require about 5,000, my lord. That is her petition element, my lord.
10,000. Then she must be staying in a house, rent. You have your own house.
My lord, she earns, my lord, more than 2 lakhs per month. My lord, please.
Till number 29, B.S. Nagaraj for petitioners.
Yes.
This husband's petition. The respondent is a divorcee.
What about the, it's a
Second child is also attained majority, Nikari, and this is engineer graduate.
Please come to the cause title.
Cause title, page 3, mirror.
First is the wife.
First is
Second
the wife.
is the daughter, Niharika.
Now she attained majority.
When she attained majority, date?
4 years back, 2 years back, 21.
How much is the maintenance granted?
Well, the ex parte order, 10,000 rupees is awarded.
To all?
To both, no, not the first one. First one, she took the divorce. That is also an ex parte order. I have produced the photographs.
To the wife, no amount?
No amount.
Only to 2 children it is granted.
So
how much is granted?
5,000 each.
So, now the second one has attained majority. We will say she is not entitled. Continue to pay to the third one.
5,000 I am continuing paying.
Yes, the same order to the second one till the age she attains majority. Till that time you are supposed to pay. We'll confirm it that round. Please come. Agreed with the orders passed in. Criminal miscellaneous number 547 of 2017 dated 18 September 2018, whereby the court had granted 10,000 maintenance to the 2 daughters. To the daughter and the son, to the 2 daughters. The husband is before this court. Land counsel appearing for the petitioner submits that the first daughter has attained majority 2 years back and she is not entitled for maintenance. This court has perused the order. The court had granted only an amount of rupees 10,000 to both the children. Now the second daughter has already attained majority. Now in that case, the petitioner is liable to pay only to the second daughter at 5,000. No, 5,000. So in this, hence this court do not find any reasons to interfere. Accordingly, the court is passing the following order. The father is directed. The father is directed to pay an amount of rupees 5,000 to the second daughter.
Second son.
Second son. So to the son. So it is son and daughter. To the son. And as far as the daughter is concerned, that 5,000 amount is liable to pay only till the date she attained majority. Yes, accordingly disposed of.
Number 30. Till number 30, Kirti Prasad.
Yes.
Matter for the petition, my lords. One petition is filed by me, other filed by the
We'll
respondent.
hear it on some other day. This is matter on 12th of August. Yes, 31.
Sir, 31. Sanjeev Gowda.
Yes.
For the petitioner, my lord, that this is the respondent petition by challenging the enhancement of the maintenance, my lord. From
Notice to the respondent.
till then, my lord,
No stay.
because from 1,500 to 10,000 it has been increased.
Notice to the respondent.
Admittedly, income is 11,000 something.
Registry is directed to issue emergent notice. Next 32.
He is a retired employee, my lord.
Geeta Devi MP.
Yes, 32.
32
Appeal
Geeta
for
Devi.
the petitioner, my lord. Lord, it's an husband's appeal, my lord, where it's been challenging the CMS maintenance proceedings, my lord. Where, my lord, in the appeal it has been admitted, both are residing in the same home, my lord. Even though it has been ordered me to pay the maintenance, my lord. Brief fact, my lord, the date of
How much amount is awarded?
50,000, my lord.
50.
Please, my lord.
My lord, the wife and 2 children, 25,000 to the wife and 12.
When they're staying with him, why they require that much
Lord,
amount?
let me explain the facts, my lord. Date of marriage was 2007, my lord.
Hmm.
My daughter was born in 2009 and the son was born in 2016.
Hmm.
She left the matrimonial home in 2022, my lord. After 15 years of marriage, she left the matrimonial home and saying that I'm not providing maintenance, I'm not looking after them, my lord. And I have filed a case for restoration of conjugal rights, where she is.
So 2022, she left the matrimonial.
Please, my lord. And then thereafter, CMS application was filed, and then she filed a memo saying that I'm ready to be with the husband, my lord. Even after that, my lord, the court has passed order saying that I have to pay 50,000 rupees maintenance, my lord. Even now, all the expenses, education, maintenance, everything is provided by me. She is housewife. But still, the order's been saying that I have to pay 50,000 rupees per month.
So what have you filed before the court to show all these expenses are borne by you?
No, that is not disputed, my lord. The only allegation she makes is upon me that I'm physically cruelting her and I'm an alcoholic person. That has not been evident to that effect.
We'll see this on 6th of August.
For interim order may be extended.
This is matter on
Mila,
6th.
one submission, Mila, because she is not paying any maintenance, even though they are sharing the same house, because the apartment was jointly purchased by them. And there is a compartmentalized. She is living separately, we are living separately. And wife is maintaining 2 children. One son, younger one is an autistic patient. He requires a lot of money for medical expenses.
This is matter on 6th. By that time, the petitioner shall place before the court the documents to show that for the welfare of for the maintenance of the children, what all he has contributed till now. Based on
Your lordship may kindly see the interim order passed on last occasion, wherein there is a specific direction that he should deposit money in the FD, and he's getting a salary of 1,77,000 rupees. He's getting salary, and 50,000 is nothing because his wife and 2 children. One son is a disabled one. I have to medical treatment and nothing. He's not paying. Even though they're sharing the same house because of the apartment was jointly purchased.
My lord, the FD was not deposited, my lord. Now, my lord, because in the meanwhile, in the March, I've filed my record saying that I've been terminated from the job. Now, what is saving that has been I've been utilizing for the education purpose of the child, my lord.
You want interim order to be continued, you have to comply and counsel for the petition. The petitioner shall comply with the interim order. If the interim order of this court is not complied with, this court will not hear the matter on the merits of it and dismiss the petition on that ground. This is matter on 6th.
Cell number 33.
6th,
Cell number 33, Nanjunda Gowda.
Petition. Husband challenge the similar 5,000 per month at trial court Malaysia is before settlement before the court Malaysia CMS Malaysia 2017 Malaysia after lapse 6 years Malaysia another CMS filed by the before the wife Malaysia.
But she is not able to maintain herself. She will file. Is there any bar? 5,000 will not interfere.
Malaysia settle the before the mediation or suppress the fact Malaysia trial court.
When was it settled?
Malaysia.
When was it settled?
Settlement 2017 mediation report kindly to produce order sheet also mediation 2017.
It's here.
This kindly to page number 6, page number 20 judgment. Para number 6 trial court not considered my.
Para number.
Page number 20 Malaysia. Para number 6 judgment Malaysia. The respondent contended that petitioner suppressed the real fact, they filed the false frivolous petition 112/2015 matter settled before the local as decision local the respondent have not you have to execute the transfer the 25 quinta 7 22 38 P 36 direction district legal service authority respondent handed the over the position till is handed over the position Malaysia. Respondent also enjoy the property Malaysia.
Now the court says,
Please.
though the respondent has vehemently contended that the petition has suppressed the material fact, but in the petition itself, she has categorically pleaded about filing of the previous petition in criminal miscellaneous for maintenance against the respondent, and that the said matter was settled before the Lok Adalat. There is no suppression.
Malaysia. Settle the matter, Malaysia, but suppress the facts, Malaysia, is not settle the matter. That is the contention of the respondent, Malaysia. That is already settled the matter, Malaysia. No,
What is suppression?
Suppress Malaysia, trial court not consider the matter, suppress my contention, Malaysia. Already settled the matter, Malaysia. Before the mediation, that is another.
Saying suppression is not stating the fact. She has already stated the fact, so there is no suppression. Now the second issue is whether the court has considered or not, we will see from the order.
Please. Only consider Malaysia is a marriage is admitted. Both are major. That the ground Malaysia maintenance is awarded. Kindly to pay 30. Consider
The order sheet discloses that the matter was not properly referred for mediation as 60 days time is not given. The respondent has produced exhibit R4, which is certified copy of the order sheet of the mediation center. The said order sheet discloses that the mediator was appointed and intimation was issued to the mediator on 4/1. As per the said order, dated 16/1/2017, the parties in this case have reported about an agreement dated 30/1/2007 agreeing to execute the registered deed so and so, and the petition is closed as settled. Except the said document, parties are not pleaded nor produced document to show that they entered into a memorandum of settlement before the mediation, and it is reduced in writing. It is submitted before the court in criminal miscellaneous. Notice to the respondent.
Malaysia, stay Malaysia 20% Malaysia. Request
When you are not paying,
Malaysia.
when is the order?
Order is Malaysia 2000. Total amount Malaysia 1,20,000 Malaysia is awarded.
1,20,000 on how much you have calculated?
28/3/2023 Malaysia. Data petition Malaysia.
You have calculated at 5,000 or half of it?
5,000 Malaysia.
Or how much it comes?
1 lakh. My income is Malaysia is a driver Malaysia, auto driver Malaysia.
25,000. It
Malaysia.
comes to your auto driver, 20,000 you learn.
Malaysia. I deposit 20,000 Malaysia. 5,000 per month.
The petitioner shall continue to pay an amount of rupees 3,000 per month, and 3,000 per month, the 5th of every succeeding month, and the arrears at 3,000 shall be paid within 8 weeks from the date of receipt of the copy of the order, or else the stay granted by this court stands vacated. Same, issue emergent notice to the respondent. Yes, 34.
Then number 34, Lakshmi Constance for petitioner.
The petitioner. This case is filed on the challenging the order.
How much is granted?
Earlier it was 3,000 to the petitioner number 1 and 2. After enhancement, the petitioner number 1 15,000 and petitioner number 2 10,000.
25,000.
Total 25,000.
What is your income?
I am a private land surveyor, licensed land surveyor.
What is recorded by the court, your income?
I have submitted the assets and liabilities, my lord. In that I have stated that 10,000 is the net income. 10,000 rupees is the net income per month.
Since the respondent is working as a licensed surveyor, getting substantial fee for the survey work.
Sorry?
No, how much is granted? 25,000. To the? 25,000 to the wife?
15,000 to the wife and 10,000 to the child, to the son, till attain the 18 years of age.
Yes,
but
half of the same order, half of the amount.
Your lordship, the petition number 2 is already a major.
What is his age now?
Now he is 18. At the time of filing the petition, he is 17. The petition filed in the year 2024. Now he is completing his PUC and he is now studying
Then,
in post-study.
you have to pay the amount while he was a minor. When he attained the majority, give the date.
I will.
Monday, let's just matter on Monday. Yes, next.
Till number 35, preliminary hearing being closed.
For the respondent in the first matter.
Actually, this should not take more than 10 minutes, my lords, because each of the petitions, I think the first one, my lords, is regarding
Have to hear it finally, not today. We'll have it some on Wednesday.
Alert 7182 will take some time. That is the connected matter. But
No,
my lords, the
but
first
no
matter.
piecemeal business. We will have it at once. If
Please,
you,
please.
if it is convenient to both of you, I'll take it up on 12th of August.
12th is fine, my lords. The
12th of
matter,
August.
12th of August, matter before the same parties are listed in the family
And
court.
then in that court,
My lord circular would.
11th of August. 11th of August. We'll
plus
take up.
not 11th, I think there is 11th, one more matter of hers is in there in the, plus next week, any
We have
date, is
so
that
many
possible?
litigations at the August, I think the
So
first
sixth,
week
my
is
lords,
not-
Wednesday.
Not 5th, we'll have 6th.
6th.
List
Sixth,
these
okay
matters
with
on 6th.
Please, please, please. Great.
Grateful.
Till
Yes,
number
please.
36. 36, Gopal Krishnamurthy.
Pleasure.
Petitioner.
Respondent.
Not the petitioner is before your lordship, my lord, the challenging the impugned order passed by the honorable first additional family judge in MC number 802 of 2018. Say as per the application filed by the respondent herein under section 24 of the Hindu Marriage Act, my lord, interim maintenance.
What is the amount?
The amount ordered
Where
is,
order impugned?
my lord, that your lordship will get page number 134 annexure H.
134.
Annexure H, my lord. 21,000 is ordered, my lord.
21,000.
Yes, my lord.
To the wife and
Only wife, my lord. No issues.
20.
21,000, my lord.
What is your salary?
But his salary was 62,000 by that time.
Now,
My lord, now 69, my lord.
what is her qualification?
My lord, her qualification is BCom.
Hmm.
She is a degree holder. And moreover, my lord, she has suppressed the fact before the honorable trial court that, my lord, though she was earning.
You said quoted granted 21,000.
Yes, my lord. And moreover, my lord, the honorable trial judge, my lord, while passing the order, he categorically held that, and she is earning 22,000 per month. That is also observed in the order. Even then, my lord, the honorable trial judge was pleased to order for 21,000 per month.
Yes.
My lord, the issue is, and moreover, my lord, before filing this petition, my lord, there was a settlement between the respondent and the petitioner, and she received as permanent alimony of rupees 9,75,000, and that has been transferred by the petitioner to her account. And I have produced the statement of account also. And she has, we have specifically said in the assets and liabilities column, my lord. But my lord, now she never means even denied, and she never mentioned in her assets and liabilities. She suppressed that fact. And for that, my lord, we have filed the application before the honorable trial court for perjury proceedings. My lord, that she has not filed any objection statement, that is disposed of on the ground that, my lord, it will be heard on merits. So now, my lord, she has suppressed all the facts, and she was able to obtain the order of the honorable trial court, my lord. And it is all on record also.
Yes.
Your lordship, first and foremost, the salary that comes is rupees 1 lakh.
First and foremost is about the alimony. Have you received the permanent alimony?
Yes.
Your lordship, that I'll confirm it. The reason is that there is a suit pending in Ramnagar court in which the family have paid him a 1 crore rupees in respect for the construction of the property.
Whether you have received the permanent alimony, where are the.
That I have to check because later on I came with an NOC vakalat. Let me check that part.
Counsel for the petitioner submits that the wife had taken permanent alimony of an amount of 9 lakhs.
75,000.
So 9,75,000. The
Yes,
same
ma'am.
was transferred to her account.
Yes.
And this fact was suppressed by her in a statement of assets and liabilities, and nowhere it is stated in her application. Then counsel for the respondent submits that he'll get instructions. He shall get the specific instruction in this regard. List this matter on 18th of August.
Kindly extend the interim order.
Interim order earlier granted is extended. Yes,
Grateful.
37. Hegde Veena. Sai Khan for petitioner.
Petitioner. But my kindly out on Monday, my lord. My senior is went to Dharwad High Court, my lord.
I am responding. I have received 1 week back. I am ready to argue. This is the difficulty, my lord. 1 minute, my lord. Already reduced. Only the son is there. Nearly one.
Asking for adjournment. Now, whatever arguments you say that the court cannot consider.
No. I respect your submission, my lord. After getting already the order is communicated to the trial court, my lord, the family court. Now reduce the, you are very difficult to peace, nearly peace it's my
This is matter on 12th of August. Yes.
my lord, date maybe.
12th of August.
Number 38, Purnima.
At the request of Land Counsel, the petitioner list on 12th of August. Yes, 38.
I am ready to, my lord, ready to file counter claim or excess amount, even though 12 lakh is very, 12,000 is very difficult to leave the.
Next part.
38, Purnima.
Please, my lord.
The respondent, my lord.
A pro bono matter,
Yes.
please. It's a husband's petition, my lord, challenging the impugned order passed by family court, awarding 4,500 rupees as interim maintenance. And your lordship were pleased to hear at the time of admission that the petitioner lives on a government old age pension, and all the properties are in the.
Age of the petitioner?
My lord, he is 74. And all the properties are in the hands of his wife. She files a suit, seeks a permanent injunction and declaration. May I take your lordships to page 44, my lord.
40?
4. It's a judgment in a OS that she had filed. Respondent has filed.
What is that, the property?
My lord, there are 3 landed properties. All the land.
Let's see the schedule of the property. Valuation slip.
My lord,
What is, what are the extents of the property? Schedule. 1
Lord,
acre 36 guntas.
my lord, one property is 1 acre 28
1 acre
guntas.
35 guntas.
Other property, my lord, is 34 guntas.
1 acre 24 guntas.
Another property is 34 guntas.
I've seen that. So now the suit is decreed.
No, my lord. Interim maintenance is our suit is decreed. Holding, she claimed in her plaint that she is in possession. For a minute, I want to take your lordships to page. Yes. Once again, my lord, may I take your lordships kindly to page 44.
What is this?
ಅಲ್ಲಿ ಎಲ್ಲಾ ಪ್ರಾಪರ್ಟಿ ಅವ್ರ ಹತ್ರನೇ ಇದೆ.
Understand.
ಕೋರ್ಟಿಗೆ ಹೋಗಿ ಹೇಳ್ತಾರೆ ನನ್ನ ಹತ್ರ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಟು ಪ್ರೊಟೆಕ್ಟ್ ಪೊಸಿಷನ್.
ಈಗ ಪ್ರಾಪರ್ಟಿಲಿ ಅವರೇ ಎಂಜಾಯ್ ಮಾಡ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ
Both
ಏನ್
of
ಬರ್ತಿದೆ.
you argue in Kannada, then I'll not understand anything. Then I'll pass orders basing on my understanding of this.
My senior counsel is another court, my lord. Please time for Monday or Tuesday, my lord, this matter.
My lord, I come from Dharwad every Friday.
I heard your arguments. I'll hear them and pass orders.
Please.
Heard the senior counsel appearing for the petition.
My only submission to lordships kindly is that he lives on old age pension 1,200 rupees per month.
Land counsel heard the land counsel for the senior counsel appearing for the petition. For the arguments of land counsel for the respondent, list this matter on 5th.
The only stress is having sufficient means unable to maintain herself.
39,
Oblige, my lord.
Lokesh BR appellant.
For the appellant.
My lord, may I request to for a date 22nd, my colleague will be there.
Tuesday it's coming.
22nd again, Friday.
I don't have to come. No arguments in that. I have heard your argument. I've already recorded that.
Posted on 5th.
Posted on, yes, 5th.
Please, oblige, my lord.
For the appellant, madam. Case of injury, madam.
Who is appearing? Where is Mr. Krishna Swami?
Krishna Swami, sir.
List the matter on Thursday because all MFAs I'm taking on Thursday.
Thursday, madam. Please.
This is matter on Thursday. We call that passed over matter.
Pass over. 13% pass over matter.
Yes, Mr. Counsel.
Your Honor, the memo filed is for the listing of 3 matters in the family court, which may be listed for the mediation, Your Honor. I am agreed to that part. Rest, Your Honor, any subsequent date of maybe 5th of this month may be
Why
given.
these so many? I don't understand. No, you have if you have accepted for something, that would be recorded here and you go before the court. It's a formal settlement. Have you agreed? Are you agreeing on that or not?
Yes, Your Honor. But the formally the signing of the settlement.
Not signing. I'll say in the light of the so and so. No, nothing survives for consideration in this petition. They'll go before the mediation before the mediation center and they'll file the appropriate petition, application.
Your Honor.
Huh? Yes, the parties. It is stated that the parties have agreed on certain terms
Your
and
Honor, my
conditions.
only thing pertaining to that was because, Your Honor, since morning I am available here and it was yesterday it was discussed. Your Honor, it has been 1.5 hour that the learned counsel.
No, why it is not given to him in advance? How can you, it is stated before the court that it is already settled.
Ma'am, the memo was actually discussed in his presence and it was agreed by him. And then it was just typed and given by Gunjal sir.
Should be done, it should be done before, unnecessarily wasting time. Made a mention day after tomorrow, giving him time, I gave it today. It can't be surprise for the party.
Because
Look
we have
at
been
it.
sitting.
When do you want?
No, Your Honor, I have looked at it. My only humble submission I beg before Your Honor, if there is any deviation, because the way the opposite.
Submitted that both the parties will appear before the mediation. On what date?
Tomorrow is the mediation, Your Honor, for signing.
The matter is coming up before the mediation center and they want to withdraw, MC number
4871 of 22.
MC number 4871 of 2022, execution case number 139 of 2025, and execution number 121 of 2024. Accordingly, the matter is referred to the mediation. After the report shall be placed before the court after the mediation is done.
I'm grateful. Your Honor, the matter may be placed specifically before mediator advocate Sushila ma'am.
This is already mediated as per the orders passed by this court. The senior counsel, the Sushila, has already mediated the matter. The matter shall be placed before the court and the report shall be placed before this court once the agreement is the parties enter into a compromise.
I'm very grateful.
Any matters?
Obliged.
Hello, madam. Madam.